Good evening, students. Welcome back. I cannot share what is going on. Anyways. Huh? Okay. First of all, okay. Ki whatever we are about to end fundamental rights. Okay. So, fundamental rights are very important. Fundamental rights and directive principles, they will be asking a question in prelims as well as in mains. Okay. If you have not understood, it is, if we have a class of 900, it is very likely that there would be 10 students, 20 students, or maybe 30 students who have not understood. So, and if I get to know, I get very personal. I really feel hurt if somebody never, it is matter which is beyond professional. Because if I'm giving my 100%, I want you. So, whoever did not understand something, believe me, did you ever give yourself a chance? Did you study once? Did you once open the book? If you will open the text, if you'll read once basics, okay, then you would be able to, thank you Sudhir ji, then you will be able to understand. एक बार आप कोशिश कीजिए, anybody who has a problem, who is not understanding or who has any issues, this is the last class we have during the day, 5 to 8 is the last thing, we can sit after the class, no problem. The purpose is that you should understand. Okay, so now I will very briefly revisit all the fundamental rights, then we'll start. Okay, so that you don't, we have article 34 and article 35. 35 तो चलिए कोई बात ही नहीं है, but 34 is like in news because of Armed Forces Special Power Act. Okay, so first we'll revisit what we have done as a, लगे वक्त कोई बात नहीं, वक्त लगे कोई बात नहीं, आपको समझ में आना चाहिए. Okay, so we'll revisit what we have done, all the fundamental rights, and if anybody has a problem, has a problem, you can meet me after the class. Okay, किसी को भी समझ में नहीं आ रहा है, कोई भी इशू है तो आप मुझसे क्लास के बाद मिल सकते हैं. ठीक है. Okay. Some are like, many are like understanding like anything, but some also why. You are giving you your time, resource, of course money, and of course your best years of your life, so you should understand. ठीक है. So briefly I'll visit fundamental rights. ठीक है. So right का मतलब, right is something which is a legally protected interest. मतलब if it is given to you and if it is violated by someone, so you have a remedy. कोई भी ऐसी चीज आपको दी जाती है, अगर वायलेट की जाती है तो आपके पास कुछ ना कुछ इलाज है. सो राइट्स आर लीगली प्रोटेक्टेड इंटरेस्ट. दोज राइट्स विच आर कमिंग फ्रॉम द कॉन्स्टिट्यूशन आर कॉन्स्टिट्यूशनल राइट्स. दोज राइट्स विच आर इनसाइड पार्ट 3 ऑफ द कॉन्स्टिट्यूशन, जो पार्ट 3 में है कॉन्स्टिट्यूशन के, दे आर fundamental rights, but not necessary that every right is there in the constitution. There are hundreds of rights which can emanate from any piece of law. Ordinary law is, ये तो समझते हैं ना, ordinary, there are thousands of ordinary laws, but there is only one constitution. And even before the constitution came into being, there were hundreds of laws. Even after the constitution has come into being, there are hundreds of laws, but this constitution is supreme. All the laws must be in harmony with the constitution. If they are not in harmony, मतलब constitution के हिसाब से नहीं है, तो they will be declared as null and void. Part 3 of the constitution is very important. Part 3 of the constitution is very important because it establishes India as a democratic state. Without fundamental rights are called Magna Carta of the constitution. If there is, for example, for anything, for Magna Carta is something which is very important. For example, India Gate is a sort of symbolic Magna Carta for Delhi or Qutub Minar. So something which is very, very important. So fundamental rights were termed as Magna Carta of the Constitution. क्यों? बिना fundamental right के Indian state would become a totalitarian state. एक ऐसा state बन जाएगा जहां लोगों के अधिकार की इज्जत नहीं होगी. It will become a totalitarian state. It will become an authoritative state. Why you are allowed to speak? And nobody can stop you from speaking. Because there is freedom of speech and expression. Why you are allowed to follow your religion, which is very personal and dear to you? Because there is a fundamental right to practice your religion. Why you walk on the road and nobody arrests you without reason and put you in jail as per their whim and fancy? Because there is Article 21. Why you can travel everywhere in the country? Because there is Article 19(1)(d). Why in public employment सिर्फ नेता के भतीजे का नहीं होता है, आपका भी होता है? UPSC is absolutely fair because there is Article 16. So fundamental rights are establishing India as a democratic state. What is democracy? Power should be with the people, not with the selected few. कुछ लोगों के पास पावर नहीं होगा, सबके पास होगा. So how democracy is ensured? Do you think Indian democracy is complete without fundamental rights? Fundamental rights stop the state from being a totalitarian state. State को totalitarian होने से रोकता है. Fundamental rights state की power को it limit करता है. Okay. So very in a very what you call fast mode, we'll try to cover all the rights. ठीक है. सबसे पहले, if you are being confined by an individual, अगर आपको कोई एक इंडिविजुअल कन्फाइन करता है, तो where will you go? You'll go to Supreme Court or police station? Police station. So fundamental rights are available mostly against the state. अगर state violate करता है तब, मैं violate करूंगा आपकी fundamental rights, so you will go to police station. So most of the fundamental rights are violated against this. For example, I have a shop, Lalu Halwai, XYZ Halwai, any Halwai, Bhondu Halwai, okay. So Bhondu Halwai, if I give the propriety of that shop to my child, okay, अगर मैं अपने होने वाले बच्चे को दूंगा, ठीक है, तो अगर मैं बच्चे को दूंगा, अगर बच्चा होगा तब, तो उसको दूंगा, तो पब्लिक एम्प्लॉयमेंट होगा कि प्राइवेट एम्प्लॉयमेंट होगा? सो दैट आई एम वायलेटिंग. इफ पड़ोसी का बेटा बोले नहीं मुझे भी चाहिए, सो ही डज नॉट हैव अ राइट ओवर माई property, because fundamental rights are not available against private individuals. They are available against state. So if I do not allow you to travel, you will go to the police station. So what is the most important thing? That fundamental rights are available against the state, so I should define state. So Article 12 attempts to define state. State define करना इसलिए जरूरी है क्योंकि fundamental rights जो हैं वो available against state है. So for example, union government passes an order which is against fundamental right. So union government is state under Article 12. Parliament of India अगर कोई law बनाता है which is against fundamental right, so Parliament of India is state under Article 12. State government कोई order pass करती है, it is also state under Article 12. State legislature अगर कोई order pass करता है, state, every state you have a legislature. अब ये कोई नहीं जानता है तो फिर तो मतलब अब ये नहीं जानता है, मैं जानता हूं, तो फिर इसमें आप में प्रॉब्लम है ना, फिर तो मतलब यू हैव टू रिविजिट लाइफ. ओके ओके. सो स्टेट, एवरी स्टेट हैज अ लेजिस्लेचर. आई विल एक्सपेक्ट that when I'm talking about humans, I will expect that you know that there are homo sapiens humans. That if then I need to tell there are male and female, तो फिर I'll start from chimpanzee. Okay. ठीक है. अब है कि there is a state legislature. If you are from UP, in Lucknow there is a state legislature. In UP you have a council of ministers and you have a judiciary, high court. Similarly at central level you have a union parliament, you have a council of ministers, you have a legislature, that is parliament. So union government, Parliament of India, state legislature, state government and state legislature, local authorities. Local authority मतलब पंचायती राज institutions and urban local bodies and other authorities. This is the definition of state. अगर ये कोई ऐसा काम करते हैं जो आपकी fundamental right violate होती है, अगर ये कोई ऐसा काम करते हैं तो फंडामेंटल राइट वायलेट होती है, तब आप सुप्रीम कोर्ट जा सकते हैं. सिंस फंडामेंटल राइट्स आर अवेलेबल अगेंस्ट द स्टेट एंड दिस इज द डेफिनेशन ऑफ स्टेट, इफ दीज इंस्टीट्यूशंस वायलेट योर फंडामेंटल राइट यू कैन गो टू सुप्रीम कोर्ट. दैट इज द डेफिनेशन ऑफ स्टेट. नाउ यू हैव आर्टिकल 13. एवरीथिंग शुड बी रिटन. मुंह से तो कुछ नहीं चलता है ना, एवरीथिंग शुड बी रिटन. आर्टिकल 13 सिंपली सेज any law that takes away your fundamental right will be, simple language में समझिए, any law that takes away your fundamental right will be held null and void to the level of violation. यानी कोई भी law, ordinary law, जैसे इंफॉर्मेशन टेक्नोलॉजी एक्ट 2000, जैसे इंडियन पीनल कोड 1860, जैसे क्रिमिनल प्रोसीजर कोड 1973, कोई भी ऑर्डिनरी लॉ अगर फंडामेंटल राइट को वायलेट करता है, इफ एन ऑर्डिनरी लॉ वायलेट्स योर फंडामेंटल राइट, देन दैट लॉ विल बी डिक्लेयर्ड unconstitutional only to the level of violation. If Income Tax Information Technology Act 2000 has 79 sections, इतना बड़ा एक्ट है, उसमें एक सेक्शन वायलेट करता है, only one section violates fundamental right, so only that section will be declared as null and void. Okay. You are getting my point? Only that section will be declared as null and void. So Article 13 simply says any pre-constitutional law, constitution आने से पहले, और एनी पोस्ट कॉन्स्टिट्यूशनल लॉ, कॉन्स्टिट्यूशन आने के बाद, अगर फंडामेंटल राइट्स का वायलेशन करता है, इफ दे वायलेट फंडामेंटल राइट, इट विल बी डिक्लेयर्ड null and void. So which law I am talking about? Ordinary law or constitution amendment? Or सिर्फ ordinary law. There are thousands of ordinary laws, but there is only one constitution. If these thousands of ordinary laws violate the constitution, then that violation, that law will be declared as one last thing. Is there is a conflict between fundamental rights and ordinary law? Who will win? Fundamental law. Always ordinary law should be in perfect harmony with fundamental right. This is written in Article 13. Article 14 is the general principle of equality. कहता है, I'll just take 20 minutes. Article 14 simply says equality before law, equality before law and equal protection of laws. मतलब equality before law is a negative concept. इस क्लास में 900 बच्चे हैं, जितने भी 400 बच्चे हैं, जितने भी बच्चे हैं, if two of them are not feeling well, if Vision IS will provide them juice, some substantive meal, and they will also drop them as at their home. Okay, so if equality before law ka chale, to if meal is provided to 2 children who are ill, 2 candidates, then meal sabko milegi. There is negative discrimination. If anything is given to one person, it should be given to everyone. That is equality before law. Absence of special privilege. किसी को भी special privilege नहीं मिलेगा. Equal protection of laws कहता है, it is a positive concept कि नहीं, 2 people are ill, so their health is low than the health of other people. वो उनकी जो सेहत है वो दूसरों से बुरी है, तो पहले उनको बराबर पर लेकर आओ, उसके बाद बात होगी. यानी फर्स्ट देयर हेल्थ इज लो, फर्स्ट गिव देम मील, मेडिसिन, कन्वेंस, नाउ दे विल कम ऑन इक्वल पेडेस्टल. सो इफ यू आर गिविंग देम मील और ड्रॉपिंग देम टू देयर होम, इट इज नॉट समथिंग एक्स्ट्रा विच इज बीइंग गिवन, इट इज एक्चुअली ब्रिंगिंग देम एट पार विथ अदर्स. अगर वो नीच कम है, कोई विजुअली इंपेयर्ड है, तो इन विजुअली इंपेयर्ड कैंडिडेट दे आर गिवन 1 hour extra in examination. So if they are given 1 hour extra, it doesn't mean something extra is being given to them. They need that 1 hour extra to be at par with other candidates. So equal protection of laws कहता है, people who are placed in similar circumstances shall be treated similarly. People who are not placed in similar circumstances shall not be treated similarly. Scheduled caste category group से हम, our brothers and sisters from scheduled caste category, they will be treated as one group, and unreserved category will be treated as one group. Yani it allows discrimination. And what discrimination it allows? Positive discrimination. वो allow. So if the Constitution of India had only equality before law, then any differential treatment would not be permitted. चूंकि Constitution में दोनों बातें हैं, equality before law भी और equal protection of laws. So one thing which the Supreme Court always, every day the government does positive discrimination. हर चीज में. DDA की housing complex आई, there is a reservation for SC ST. Ministry of Minority Affairs is having 15-point program for minorities. You have scholarship in colleges. Our brothers and sisters from SC ST communities pay less fees. So everywhere there is a discrimination. मतलब that is a positive discrimination, and that is called reasonable classification. जब भी एक community को अलग treat करते हैं, you treat a community differently. Only one thing Supreme Court will check, whether that classification is reasonable or arbitrary. अब ऐसा सरकार करेगी अगर कि white shirt वालों को 2 लाख रुपए महीने मिलेंगे, जो व्हाइट शर्ट पहनेगा उसको 2 लाख. सो दिस इज नॉट अ, all those who wear white shirts on Monday would be given 2 lakh rupees per month. So this is not a reasonable. So who will check? Supreme Court and High Court, both the courts have power of judicial review, and High Court has independent power of judicial review, and it is basic structure of the Constitution. L. Chandra Kumar versus Union of India, 1997, Supreme Court ने rule किया. So equality before law and equal protection of laws. Next you have Article 15. Article 15 is general. कि state shall not be discriminating on the grounds of religion, race, caste, sex, place of birth. इन ग्राउंड्स पे, रिलीजन के ग्राउंड पे, रेस के ग्राउंड पे, कास्ट के ग्राउंड पे, सेक्स के ग्राउंड पे, प्लेस ऑफ बर्थ के ग्राउंड पे डिस्क्रिमिनेशन नहीं हो. देन इट इज अ जनरल पब्लिक बेथिंग घाट, नहाने की जगह, पब्लिक रेस्टोरेंट्स, ऑल दीज प्लेसेस देयर विल बी नो डिस्क्रिमिनेशन. अब एक लाइन है, स्टेट कैन मेक स्पेशल प्रोविजन फॉर विमेन एंड चिल्ड्रन. विमेन और चिल्ड्रन के लिए अगर स्टेट इज रिजर्विंग सीट्स इन डीएमआरसी, इट विल नॉट बी सीन एज वायलेटिव ऑन द ग्राउंड ऑफ सेक्स. So there are seats reserved for women. Then it says the state can make special provision for socially and educationally backward classes and SC ST. Socially और educationally backward classes के लिए भी state कोई व्यवस्था कर सकती है. Then reservation for SC ST and OBCs in higher educational institution, or finally 10% reservation for economically weaker section. Article 15 is a general article. From pen to aeroplane, everything is covered in Article 15. Article 16 deals with only one thing, that is public employment. Public employment में discrimination नहीं हो सकता. UPSC never discriminates. So religion, race, caste, sex, place of birth and place of residence के ground पे discrimination नहीं. Although the state can provide reservation. This is Article 16. Now Article 17 कहता है, this article Supreme Court says is the most absolute article. Absolute मतलब discrimination in any form is not permitted. अगर एक fundamental right आप मुझसे पूछिएगा which is most absolute in nature, I can tell you it is Article 17. Untouchability is abolished and practice in any form is forbidden. Why the founding mothers of the Constitution did not mention untouchability on the basis of caste? They knew that the term untouchability should be interpreted in a very wide sense. So Article 17 is absolute. No untouchability is abolished and is an offense according to law. अगर आप untouchability practice करते हैं, if you are practicing untouchability, it is an offense. वो एक अपराध है. In IPC we use the term offense, we don't use the term crime. So crime is a general term. So it is a criminal offense. Okay. So if it is an offense, you will be sent to jail. So that is untouchability, Article 17. Article 18 कहता है, अब पहले के जमाने में जो अंग्रेज के खास होते थे, the people who were close to Britishers, they used to be given title as Rai Bahadur, Sir, so that there was a close quid pro quo. Quid pro quo means legal language में आपने मुझे फायदा दिया, मैंने आपको फायदा दिया. That is quid pro quo. So do you think in independent India, Mr. X getting down from Bentley and is being called Rai Bahadur, and Mr. Y, who is an equal citizen, getting down from DTC and is called no Rai Bahadur? So is it wrong na कि this is creating arbitrary distinction in the society? So Article 18 कहता है, state कोई भी title नहीं दे सकता है किसी को. State cannot bestow title on anyone. Indian state कभी किसी को Sir, Rai Bahadur, Khan Bahadur, any such title shall not be bestowed except military or academic. Military title PVSM, Param Vish Seva, or for you Lieutenant General, Colonel, Brigadier, these are military. And academic titles, you know, doctor. If you are a graduate in medicine and National Medical Council में enrolled है, so you are a practicing medical practitioner, so you can prefix the title of doctor before your name. And also homeopathic and other doctors can also have. Okay, so this is really wrong. It has homeopathic. My father is a big fan of homeopathy. Okay, so no title can be given. एक तो इंडियन स्टेट कोई टाइटल नहीं देगा. दूसरा, फ्रांस wants to give a title or UK wants to give a title of sir to Sachin Tendulkar. Indian citizen also cannot accept title from a foreigner. ना Indian state title देगा, neither Indian state will give title nor foreign Indian citizen can accept title from foreigners. If UK wants to give me sir, okay, so I cannot accept. Okay, that is something. So third is, any foreigner who is working in India, अगर कोई फॉरेनर इंडिया में काम कर रहा है, ही विल ऑल्सो नॉट एक्सेप्ट टाइटल फ्रॉम अ फॉरेन स्टेट विदाउट द परमिशन ऑफ प्रेसिडेंट. सो दिस इज व्हाट यू हैव आर्टिकल 18. आर्टिकल 19 जो है ये बहुत रेस्ट्रिक्टिव है. एवरी आर्टिकल में आपको राइट है, यू आर गिवन सर्टेन राइट, पर रेस्ट्रिक्शन है. जैसे यू हैव अ फंडामेंटल राइट टू स्पीच एंड एक्सप्रेशन, बोलने की और अभिव्यक्ति की. अभिव्यक्ति तो किसी भी तरीके से हो सकती है, इशारे से, कुछ भी हो सकता है. ओके, सो वी हैव लाइक दिस, सो वी हैव जेस्चर्स, सो ऑल फॉर्म ऑफ एक्सप्रेशन, बट इट कैन बी रेस्ट्रिक्टेड. सरकार चाहे तो आपकी बोलने की आजादी को रेस्ट्रिक्ट कर सकती. क्यों? व्हेन द स्टेट कैन रेस्ट्रिक्ट, इफ बाय लॉ, if you are speaking against the state, if your speaking is detrimental to security of state, if you are speaking defamation, किसी को बदनाम कर रहे हैं, if you are speaking against the court, so all these are the grounds on which your freedom of speech can be restricted. So article 19 में जो speech है, ये rights, I'm very briefly revising everything. We have article 19, you know that A is speech and एक्सप्रेशन. आपको फंडामेंटल राइट है बोलने की और अभिव्यक्ति की. बोलना इज वेरी सिंपल, कम्युनिकेटिंग स्पीच, बट एक्सप्रेशन कैन बी थ्रू व्हाट्सएप, कार्टून, फेसबुक, एनी फॉर्म ऑफ एक्सप्रेशन. देन यू हैव आर्टिकल 19(1)(b, राइट टू असेंबल पीसफुली विदाउट आर्म्स. एज अ सिटीजन, इफ यू वांट टू प्रोटेस्ट एनीथिंग, सो यू कैन असेंबल पीसफुली विदाउट आर्म्स. सो यू शैल नॉट बी यूजिंग आर्म्स. आर्म्स का रखने का फंडामेंटल राइट यूएस में है, इंडिया में नहीं है. सो इट इज यू राइट, फंडामेंटल राइट टू असेंबल पीसफुली विदाउट आर्म्स. देन यू हैव सी राइट टू फॉर्म एन एसोसिएशन, यूनियन और कोऑपरेटिव. आपको एक फंडामेंटल राइट है, यू कैन फॉर्म एन एसोसिएशन, यू कैन फॉर्म अ यूनियन और यू कैन फॉर्म अ कोऑपरेटिव. आर्टिकल 19(1)(d, you can travel throughout the country. Of course, your travel can be curtailed in the interest of general public and scheduled tribe. E है reside and settle, F has been deleted, and G है practice any profession. आपको हक है कोई भी प्रोफेशन, ट्रेड, बिजनेस, ऑक्यूपेशन you can do. Only the state can restrict and prescribe certain qualification, or if the profession is against the Secretary of State, of course the state will not allow that. So you have Article 19. Now you have Article 20. 20 is very important. Why? Because 20 and 21 cannot be suspended during emergency. All fundamental rights can be suspended, but 20 and 21 cannot be suspended. This is written in Article 359. कि Article 20 and 29 cannot be suspended even during national emergency. Okay, we'll see what is that. So 20 says three things. No ex post facto law. Simple language में कोई भी क्रिमिनल लॉ को पीछे से अप्लाई नहीं कर सकते. यू कैनॉट अप्लाई अ क्रिमिनल लॉ रेट्रोस्पेक्टिवली. फॉर एग्जाम्पल, इफ यू स्लैप्ड समवन, आज आपने किसी को स्लैप किया 13th of April. 13th of April, slapping someone, the punishment is 6 months. Tomorrow the parliament amends the law and says if you slap someone, punishment is 1 year. जिस दिन आपने स्लैप किया था उस दिन क्या पनिशमेंट था? व्हाट वाज द पनिशमेंट ऑन द डे ऑफ स्लैपिंग? 6 months. सो ऑफ कोर्स क्रिमिनल लॉ कैन नॉट बी रेड, पीछे से अप्लाई नहीं होगा. यू विल बी पनिश्ड ओनली 6 months, नॉट 1 year. एंड नो सेल्फ इंक्रिमिनेशन. आपको फोर्स नहीं किया जा सकता है कि अपने गुनाह को कबूल करो. यू कैन नॉट बी फोर्स टू बी अ विटनेस अगेंस्ट योर सेल्फ. इट इज द ड्यूटी ऑफ प्रोसिक्यूशन टू प्रूव कि आपने गलती की है. नॉट, यू शुड नॉट बी फोर्स टू बी अ विटनेस अगेंस्ट योर सेल्फ. एंड नो डबल जेपार्डी. You cannot be punished for the same crime twice. That is, now we have Article 21, which is right to life. No person shall be deprived of life or personal liberty except procedure established by law. Long debate है. Right to life में बस एक छोटी सी बात I said in the morning also. छोटी सी बात से मुझे. Anyways, so procedure established by law and due process of law. What is reasonable? Article 21 में सुनिए. Okay, he is a poor man. Okay, nobody is disturbing him. He is a poor man. Nobody is disturbing him. Nobody is taking away his life. उसको सुकून से जीने की. Don't you think his child should go to school? His child should also get vaccine. He should also get vaccine. So उसको मिलना चाहिए. सिर्फ उसको जीने की आजादी क्या enough है कि ठीक है भाई तुम्हें कोई पीटेगा नहीं और तुम जिंदा रहोगे? Is it enough to just allow him to live? Dadabhai Naoroji said in his book Poverty and Un-British Rule in India, where the Britishers used to say कि we have improved the law and order in India. We have improved the law and order. Dadabhai Naoroji said, poor man is allowed to starve in peace. Poor man is allowed to starve in peace. आपने उसको पीस तो दे दिया, पर उसको चाहिए कि नहीं चाहिए? Okay, so the point, आजकल तो जैसे जैसे सोसाइटी प्रोग्रेस करती, you see, you must have studied in economics, the expenditure on food is decreasing. Okay, so the point is कि Article 21 means your life cannot be taken away or your personal liberty cannot be curtailed until you have broken a law. जब तक आपने लॉ नहीं तोड़ा है, आपकी जिंदगी से आपको वंचित नहीं किया जाएगा और जेल आपको नहीं भेज. लेकिन सुप्रीम कोर्ट सेज नहीं, just by allowing him right to life, it is not enough. Give him more. So give him more में right to speedy trial, right to travel abroad, right to healthy environment, right to health, राइट टू रेप्यूटेशन. ये सारी चीजें मिलेंगी तभी जिंदगी मुकम्मल होगी. लाइफ वुड बी कंप्लीट ओनली विथ दीज थिंग्स. इट सो राइट टू लाइफ हैज बीन expanded by the Supreme Court. And do you think that it will not be expanded? और हो गया जो होना था. Tomorrow the Supreme Court will rule that right to internet is also a part of right to. अभी Kerala High Court has ruled. So judgment of one High Court is persuasive value, not binding value. It can be mentioned in Supreme Court and other court, but it cannot have binding effect. Judgment of Supreme Court is binding. Article 141. Binding term use हुआ है कि judgment of Supreme Court is binding. So can Article 21 कल हो सकता है एक necessity हो कि every citizen should be given something which is the demand of the hour. So Article 21 will keep on expanding and Supreme Court will expand. जैसे right to marry, UPSC ने पूछा 2019 में, right to marry someone is a part of right to life. Right to privacy is a part of right to life. So Article 20, यानी जिंदगी सिर्फ जानवरों जैसी नहीं हो. Supreme Court कह रहा है, मैं नहीं, मेनका गांधी केस, that life should not be mere animal existence. I am lifting a quote from Supreme Court judgment. Life should not be mere animal existence. So Article 21 का जो value है, and which liberty is it? Negative or positive liberty? Expansion of choices is negative liberty or positive liberty? Positive liberty. This is what John Stuart Mill said. Now we have Article 22. I'll take your question also. 21A, हाँ. 21A तो मालूम है 6 से 14 साल के बच्चों को फ्री और कंपलसरी एजुकेशन सबको. All children means children of citizens, illegal migrants and everyone. All children in the territory of India shall be given free and compulsory education up to the age of 6 to 14 in the manner state may determine by law. State कहेगा law के जरिए. ये नहीं कि बच्चे कहेंगे नहीं मुझे तो लैम्बोर्गिनी में जाना है स्कूल, या मुझे हर टीचर एक बच्चे पे एक टीचर चाहिए. So teacher pupil ratio should be healthy. So in the manner state will determine by law. And what is the name of that law which the state passed? Right to Education Act. Okay, ये law pass किया. Article 22 is again very important. It says किसी को भी arrest करेंगे, anybody will be arrested, he will be produced before nearest magistrate in 24 hours excluding the time of journey. पुलिस वाला इसीलिए कहते हैं ना, when you will understand things, then you will understand Indian police service. Many of you must have parents, relatives, almost everyone knows some or the other person. You know Indian police service in a democracy is nothing. On paper you will realize कि it is on paper कुछ भी नहीं है. कुछ, हाँ, you use the term भौकाल, okay, that may be, but on paper you cannot even order a gamla. On paper, power police को, you have to arrest someone, produce before a nearest magistrate. He will decide that what is to be done. On paper, you will conduct an inquiry. Magistrate may or may not accept that. So the police has been given limit. Gandhiji said police is a necessary evil. So police को power, इसीलिए Indian administrative service में colossal powers है. कोई comparison ही नहीं है on ground. Of course, if you are immature, you will go for that movie where he opens the gate and he's an IPS officer, and that's a diff. But within few years, you will realize. Within few years, especially after you are no more superintendent of police, then you will realize कि what is the, or you are working for a central agency, then the work culture is good. Otherwise, on paper in a democratic country, police officers have, अब डरा कर तो फिर कुछ भी हो सकता है, फिर तो भुट्टा खिला ही देगा. Okay, that's a different story. Otherwise, on paper in a democratic, so Article 22 says, whenever you arrest someone, you place that person before the nearest magistrate. Second, you give him the right to be informed the ground of his arrest. भैया मुझे arrest क्यों किया है? ये उसको मौलिक अधिकार है. He has a fundamental right to be told the ground of his arrest. And next, he has to be given an opportunity, अपनी पसंद का वकील, to have a legal practitioner of his choice. Of course, the vakil should also agree. He will say, I'll have what you call Falias Narimanji, and he is not free. So, if the vakil is also agreeing, he has three fundamental rights. Whenever he is arrested, he should be produced before nearest magistrate. Second, be informed the ground of your arrest. बताना पड़ेगा क्यों arrest किया. और तीसरा, he should be given a legal practitioner of your choice. Then there is preventive detention and all. No, abhi chhodi. Then you have Article 23. Simple. Bonded labor, begar. Gar means rozgar. Roz, wage. Be means beabru. मतलब बिना आबरू यानी बेइज्जत. बेइज्जत मतलब बिना इज्जत के. बेईमानी मतलब बिना ईमान के. So बेगार मतलब without wage. So unbonded labor, all these things, begar is constitutionally prohibited. Then you have Article 24. Children should not be employed in mines, factory or hazardous employments within age of 14. Then you have another Article 25, जो ये fundamental right देता है to practice, profess, declare that I belong to religion X, propagate, tell others about the goodness of your religion and conscience, your inner relationship with God. ये आपको fundamental. Is it absolute or qualified? ये एक qualified right है. Okay, this is a qualified right. Okay, so this is a qualified right because state can restrict it. अब है Article 26. 25 is individual right. मुझे आजादी है मजहब फॉलो करने की. Now Jews will have their synagogue, Hindus would have their temple, Muslims would have their mosque, Sikhs would have Gurdwara, although Gurdwara is mostly for temple, Gurdwara, matlab, and Dargah and all for everyone. Okay, I have been into Gurdwara all my childhood. But it is, they can open the institution. So Article 26 is a collective right or individual right? Collective right. Article 27 कहता है आपके टैक्स के पास पैसे को, सिंपल लैंग्वेज में, योर टैक्स मनी कैनॉट बी यूज टू प्रमोट एनी पर्टिकुलर रिलीजन. यानी मेरे टैक्स के पैसे को और आपके टैक्स के पैसे को, आवर टैक्स मनी कैन नॉट बी यूज टू प्रमोट एनी पर्टिकुलर रिलीजन, बट इट कैन बी यूज टू प्रमोट ऑल रिलीजन्स इक्वली. हज सब्सिडी, गुरु गोविंद सिंह जी जयंती was celebrated, बिहार गवर्नमेंट में, रामनवमी and so many, Diwali, so many festivals, and also state is giving holidays. Article 28, secular character of Indian state. किसी भी ऐसे institute में, any institute which is fully funded by government, there will be no religious instruction. If it is aided, कुछ computers दे दिया, कुछ मदद कर दी institute, even if it is aided or it is getting recognition, it can impart, but there will be no compulsory. So if there is a private school, but that is affiliated to Central Board of Secondary Education, so it is not receiving aid from state, but it is receiving recognition ले रहा है ना CBSE से, it cannot force you to go into religious instruction. There is a church, beautiful church inside St. Stephen's College, but nobody is being forced to attend the Sunday mass. किसी को force नहीं करते हैं. So if you wish, you can go, otherwise don't. So the point is, any such thing. Now we have Article 29, language, script and culture को protect कर सकते हैं, and nobody can be denied admission in educational institution on grounds of religion, race, caste, sex is missing. कि there can be a separate college for women. Article 30 एक simple सी right है जो सिर्फ minorities को है, कि minority can establish and administer and reserve 50% seats. 31 A, B, C we have seen very recently. 32 को डॉक्टर अंबेडकर ने कहा heart and very soul of the constitution. हार्ट एंड वेरी, अगर सारी राइट दे दी, इनफोर्स नहीं किया, what is the point of having a right if it cannot be enforced? So Article 32 gives you that power to move Supreme Court if your fundamental rights are violated, and power to move Supreme Court is also a fundamental right. So Supreme Court cannot deny you hearing. Getting? Then you have Article 33, जो हमने last किया था. आप ही बताइए, for the maintenance of armed forces, if they are allowed to form an association, do you think it is good for the security of the country? No. Police forces are allowed to form an association. Do you think it is good for the... If officers are allowed to speak like us, freedom of speech and expression, is it good for the country? No. So, उन लोगों की fundamental right, those people's fundamental right, which are connected with public order, intelligence, counter-intelligence, उन लोगों की fundamental right parliament restrict. So, parliament can restrict the fundamental right of those, simple language में, those government employees. उन government employees की fundamental right, which is who is connected with public order or what that matter, intelligence, counter-intelligence, armed forces, उनको association बनाने की आजादी, they do not have a right to form an association. So their fundamental rights can be curtailed in the interest of discipline and maintenance, proper discharge of their duties. This is Article 33. So this we have done. Now we have Article 34. Article 34 is contemporary, very important. क्यों? Because of Armed Forces Special Power Act. Okay. पहले समझते हैं. First of all, Article 34 is known as martial law. Okay? The term martial law is not defined in the Constitution. Constitution में martial law define नहीं किया गया. When was the last time martial law imposed in India? NEVER. Technically, it has never been imposed. Now, there is a common misconception. अभी Nagaland में there was an issue कि being Armed Forces Special Power Act was used and some people were killed. So I downloaded all the research papers related to Armed Forces Special Power Act. Armed Forces Special Power Act is not a martial law. Armed Forces Special Power Act is not a martial law on paper. Martial law के सारे powers, all the powers of martial law are there in Armed Forces Special Power Act. De facto it is a martial law. मतलब वो दिखता बिल्कुल looks like a martial law, but it is not a de jure. De jure or de facto matlab Bablu is the mukhya of the village, but Bablu is just a PAWN. He's just a piddi, pawn. Matlab, but the real power is with the real XYZ who is actually running the show. So Bablu will be the de jure head of the village, but de facto head would be the person who is running the show. So many times it is said कि अरे ये government तो उनके इशारों पर चलती है. This government runs on the direction given by that person. So that person is the de facto head and this person who is sitting on the chair just for namesake. जैसे in villages you have women. In sociology optional you must study about Mukhya Pati. The women is just a titular or ceremonial head while the real power is with the men. Okay, so this is the, although the changes are happening, you know, now we can witness the change. When in UP election, the Indian National Congress announced that we'll give 35% tickets to Priyanka Gandhi ji ne announce kiya tha na, women candidate. So a journalist asked her, see, you have to take out the constitution whenever you hear something. You go, you are traveling, you must be vigilant. Okay. So it's asked that, what do you think about 35% reservation to women candidates in assembly elections when you have given 50% in panchayats, but actually who is winning? It is the male who is running the show. Women is just for the sake of namesake. So she said ki there is a karyakarta, matlab there is a worker of my party whom I have been meeting for past years, matlab pehle bhi. He used to he used to come ki his wife has won the election, so pehle to wahi chalata tha. Now he complains to me ki mera kuch sunti hi nahi hai. So she said actually, Priyanka Gandhi, she said ki now this is not about a particular incident. This is about gradual women empowerment. You're getting my point. Now she was making a statement ki aap log wait kijiye, change आएगा, change would, and she gave an example कि now she is running the show independently, she doesn't need the advice, counsel and what you call recommendations from her husband. So this change will take time. Overnight ऐसा change नहीं हो सकता है. Now de jure, so Armed Forces Special Power Act on paper is not a martial law, and on paper is not a martial law, but it looks exactly like a martial law. अब martial law है क्या? Whenever martial law is declared in the country, Parliament can indemnify the act done by a, so indemnify का मतलब माफ कर देना. Parliament can forgive. Parliament can indemnify the act done by a public servant or any other person in connection with public order. Restoration of public order. Example. Martial law lag gaya yahan. ठीक है? Now, few people are protesting. The officer over there orders कि shoot कर दो सबको. 20 लोग मर गए. 20 people died. So, this is violation of their right to life. Because if they have committed something, they must be put to jail. So you can shoot only in defense. You cannot order. So right to life ka violation hua na. So any public official, yeah, for example, I am a commandant. I am, there is a martial law, complete civil war situation is there. Okay. Civil war situation is there. Armed forces have come in. I am the commandant. Alone I am not able to control. I will ask 7 youths of the village कि तुम लोग भी भाई थोड़ा साथ दो. Okay, so those youths are peace loving. So I'll say, okay, you also help me and restore public order. Article 34 uses a beautiful term. Any person who helps in restoration of public order or उस process में he does something, that act will be indemnified by parliament. अगर वो किसी को shoot भी कर देता है, it will be forgiven by parliament. So why it has been added, we'll comprehensively understand martial law. Okay, because the kind of faces I am saying, okay. मार्शल लॉ. सबसे पहले व्हाट इज अ मार्शल लॉ सिचुएशन, सिंपल लैंग्वेज में समझिए. ओके, नेशनल इमरजेंसी एंड मार्शल लॉ का डिफरेंस समझिएगा, तब समझिएगा. नेशनल इमरजेंसी कैन बी इंपोज्ड ओनली ऑन 3 ग्राउंड्स. इफ देयर इज एन एक्सटर्नल अग्रेशन, बाहर से एनी कंट्री इज ट्राइंग टू इंक्रोच अस. सो व्हाट आर द ग्राउंड्स ऑन विच नेशनल इमरजेंसी कैन बी इंपोज्ड? ये दोनों का डिफरेंस दे हैव आस्क्ड मेनी टाइम्स. National emergency, if there is an external aggression, some outside country is entering into our territory, or there is a war, we can also go to war. What is the difference between external aggression and war? Somebody is encroaching into our territory, it is an external aggression. We have not done anything. That is external. Tomorrow we want to go to war, it is a full-fledged war. Or armed rebellion. आर्म्ड रिबेलियन, कुछ लोगों ने विद्रोह कर दिया. सो दिस इज द ग्राउंड ऑफ नेशनल इमरजेंसी. मार्शल लॉ में ग्राउंड मेंशन. व्हाट इज अ मार्शल लॉ सिचुएशन? फॉर एग्जांपल, देयर आर 10,000 ऑफ पीपल हु सडनली कम इनटू अ सिटी, फेलियर ऑफ इंटेलिजेंस, एंड दे टेक ओवर ऑल द पुलिस स्टेशन एंड एवरीथिंग. सो कैन द जुडिशरी वर्क? नो, जुडिशरी कैन नॉट वर्क, क्योंकि अब तो शहर पे पुलिस है ही नहीं. This happened in actually Rohtak during the protest for reservation. Okay, so many parts of the city were taken over by the miscreants. Okay, so the point is कि in civil war type situation, judiciary cannot work, executive cannot work, legislature cannot work. So there is complete civil war like situation. So now the local police has given hands. Who will be called? Army and Central Armed Police Forces, CRPF. You have Central Industrial Security Force. ये भी तो है, ये तो आर्मी नहीं है ना. They are Central Armed Police Forces. They will be called. So when armed, in simple language, martial law is when the local administration fails, a situation is like that of a civil war. Armed forces and army is called to assist the local administration. Now the commandant will be coming. He will order shoot that person. So what will happen? The moment that person gets killed, it is violation of his right to life. So Article 34, I'll let you see, it says Parliament can indemnify the act done by a person by an union government employee or a state government employee or any other person. कोई भी व्यक्ति जो restoration of public order, any person is doing anything to restore public order, फिर से public order को restore करने के लिए कुछ भी करता है, उस दौरान अगर किसी की हत्या या कुछ भी होती है, it will be. So Parliament can forgive the act done by a government employee or any other person in connection with restoration of public order. This is martial law, and it is actually fundamental rights are not suspended per se. Rights तो suspend नहीं हो रहे हैं, पर if they are violated, you don't have a remedy. आपकी right violate हो गई if you were killed or you were made to, your hands were cut. Although they will not do this, but just saying, your hands were cut, so your right to life was violated, but you don't have a remedy. आप कोई केस नहीं. क्यों? क्योंकि Parliament can forgive Parliament can forgive the act done by a person in connection with restoration of public order. अब ये आर्म फोर्सेस स्पेशल पावर एक्ट से कैसे है? सबसे पहले आर्म फोर्सेस स्पेशल पावर एक्ट 22 सितंबर 1958. देयर आर 7 सेक्शंस इन आर्म फोर्सेस स्पेशल पावर एक्ट. कितने सेक्शंस है? 7. सो बड़ा लॉ है या छोटा लॉ है? एकदम 2 पेज का छोटा सा लॉ है. 7th सेक्शन हैज बीन डिलीटेड. 7th सेक्शन को डिलीट कर दिया. तो अभी कितना? 7 - 1 6. यू हैव 6 सेक्शंस. 6 सेक्शंस में 3 सेक्शंस आर इंपॉर्टेंट. एक सेक्शन कहता है इन नॉर्थ ईस्टर्न स्टेट्स एक्सेप्ट सिक्किम, नॉर्थ ईस्टर्न स्टेट्स एक्सेप्ट सिक्किम, whenever the union government or the state government, whenever the union government or the state government or administrator of a union territory को ऐसा लगता है, if he feels he can declare an area as a disturbed area. So अगर कहीं violence है, so कौन, who can declare? Union government, state government or administrator of a union territory. I will show you the act, everything I will show you now. वो किसी भी एरिया को डिस्टर्ब्ड एरिया डिक्लेयर कर सकता है. गेटिंग इट? वंस द एरिया इज डिक्लेयर्ड एज डिस्टर्ब्ड एरिया, अब कहता है अब पावर. नाउ व्हाट इज द पावर? द ऑफिसर कैन इंटर सर्च विदाउट वारंट, ऑफिसर कैन शूट विच मे इवन लीड टू डेथ. ये सारे लैंग्वेजेस हैं. ऑफिसर कैन गिव एनी पनिशमेंट, बट इफ द ऑफिसर विल अरेस्ट यू, यू हैव टू बी हैंडेड ओवर टू नियरेस्ट पुलिस स्टेशन. So first, declaration of disturbed area. Second, power. Once the declared area is declared as disturbed area, power. And third, section 6. कुछ भी होता है, कोई भी केस दर्ज नहीं होगा बिना सेंट्रल गवर्नमेंट के परमिशन के. So the indemnify, forgive part of Article 34 is actually कि any case will not be registered against any person without the permission of central government. अगर disturbed area घोषित है, उसने कुछ भी किया. So actually this is a very wide power, na? Kuch bhi means women. There can be violation of human rights of women, and this has been recorded. So if then no case shall be registered under 376. You're getting my point? Any IPC section, nothing will apply. Anything done, if an area is declared as a disturbed area, anything done, there is absolute indemnify until the permission is given by the central government. Many of the cases, 2 important cases there. One is Naga People's Movement for Justice. सुप्रीम कोर्ट ने एक छोटी सी बात कही, कहा यू कैनॉट डिक्लेयर एन एरिया एज अ डिस्टर्ब्ड एरिया इनडेफिनेटली. आप इनडेफिनेटली डिक्लेयर नहीं कर सकते. Whenever you are issuing a notification to declare an area as an disturbed area, every 6 months you have to review that. So this provision is not provided in Armed Forces Special Power Act, पर ये provision add किया है सुप्रीम कोर्ट ने नागा पीपल्स यूनियन केस में. Next, Supreme Court says that nobody is above law. So if there are serious discrepancies of human rights violation, there have been so many cases, then the court can order a impartial inquiry or an investigation by an outside force. So Armed Forces Special Power Act is very similar to martial law, but on paper it is not a martial law. Now some of you who are having law optional, तो पार्लियामेंट ने बना कैसे दिया? मेकिंग आर्म फोर्सेस स्पेशल पावर एक्ट, कहीं से तो पावर आया होगा. सो पार्लियामेंट लॉ तभी बना सकती है ना जब उसको पावर मिलेगा. सो इट इज यूनियन लिस्ट 2A, सिक्योरिटी ऑफ इंडिया. यूनियन लिस्ट 2 कैपिटल लेटर A इज अ सब्जेक्ट दैट इज सिक्योरिटी ऑफ इंडिया में पार्लियामेंट कोई भी लॉ बना सकती है और पार्लियामेंट ने Armed Forces Special Power Act बनाया. Now we will see Armed Forces Special Power Act, and then we will see the because this can be a mains question this year. Although you are not appearing this year, but still next year there can be a mains PDF. Okay, we'll see Armed Forces Special Power Act, and we will also see Article 35. Then we'll take online questions. Okay. So this is Armed Forces Special. I'll show you Constitution also. See, this is Armed Forces Special Power Act. Okay, so we have Armed Forces. Hey, 11 सितंबर, sorry, 1958. अब ये कितने सेक्शंस हैं इसमें, कहां कहां लागू है देखिए. अरुणाचल, असम, मणिपुर, मेघालय, मिजोरम, नागालैंड, त्रिपुरा. In these states it can be made applicable. It is not necessary that it is आसमान और जमीन का अंतर है. It can be made applicable in these states by declaring an area as a disturbed area. Does not mean that it is automatically applicable in these states. There is a provision that Armed Forces Special Power Act can be made applicable in these states only if there is a notification declaring an area as disturbed area. You're getting my point? Act is applicable to these states, but not any area will not. These all states have been declared as disturbed area. इस सारे स्टेट को डिक्लेयर्ड एरिया डिस्टर्ब्ड एरिया घोषित किया नहीं. Act is applicable in these states, then an area can be declared as disturbed area by a notification. यानी इन states के लिए disturbed area घोषित किया जा सकता है. समझ रहे हैं ना? ये क्या ऑटोमेटिकली सारे एरिया disturbed area है? No, they are not disturbed area. Now you see what is it says. It extends to the Arunachal Pradesh, Assam, Manipur, 1, 2, 3, 4, 5, 6 and 7. How many states are there in Northeast? 8 states. Sikkim कहाँ गया? And there is a ministry, donor, development of Northeast region. Department नहीं है, ministry है. It is not a department, it is a separate ministry for Northeast region. That is DONER, development of Northeast region. How many states are there? 8 states are there, not 7. Northeast में 8 states हैं, 7 states नहीं हैं. Okay. Because शुरू से cultural रहा है. Sikkim was incorporated in May 1975, so it was, and there is a newspaper, Seven Sisters Daily करके आता है. एक culture रहा है. Sikkim was not, Chogyal dynasty was ruling over there. It was added 75. It is just a cultural term, but political term. दो रीजन है. फर्स्ट, डेवलपमेंट ऑफ नॉर्थ ईस्ट रीजन करके एक मिनिस्ट्री है जो 8 स्टेट को देखती है. And there is North Eastern Council Act 1971 which establishes zonal councils in 8 states. And there are 8 states in northeastern part of the country. It is not 7, it is 8. अब देखिए कह रहा है armed forces power to declare a disturbed area. किसी भी एरिया को disturbed area कौन डिक्लेयर कर सकता है? You see, who can declare? Governor of that state, administrator of that union territory or central government. So who can declare an area as a disturbed area? जब भी violence होगा, who can declare an area as a disturbed area? Governor, यानी state government, central government or administrator of that union territory, because many states were UTs before and later on they became states. अब if an area is declared as a disturbed area, किसी भी एरिया को disturbed area declare कर दिया, अब क्या क्या हो सकता है? What can happen? Any commissioned officer, warrant officer, non-commissioned officer, if he is of the opinion that for maintenance of public order, fire upon, गोली चला दो, use force even to the extent of causing death. So you see this, if any officer is of the opinion for maintenance of public order, गोली चला दो, and even to the causing of death. So any officer can, even a non-commissioned officer can order to shoot and it may even lead to death. एक ये बड़ा पावर है या छोटा पावर है? बहुत ही बड़ा पावर है. Next, if he is of the opinion to destroy any arms dump, ये तो चलो सही. If arrest without warrant any person who has committed cognizable offense. So कोई भी व्यक्ति जिसने cognizable offense किया है उसको बिना वारंट के arrest, and whom a reasonable suspicion exists, even if उनको ऐसा शक लग रहा है कि ये इसने कुछ किया है तो फिर अरेस्ट कर सकते हैं. ओके, नेक्स्ट इज, नाउ दिस इज अ वेरी इंपॉर्टेंट पावर, enter and search without warrant any premises. So the officer can enter and search without warrant any premises. So this is actually a very big power. So you getting now, as I said, arrested persons to be handed over to the police. So it local police को दे देना है. अब protection section 6, protection under the arrest. No prosecution, suit, legal proceeding shall be instituted except with the previous sanction of the central government against any person in purported to have done anything under the act. यानी इस एक्ट के अंदर कोई कुछ भी करता है, no case can be filed except with the permission of central government. So this is providing absolute immunity, absolute immunity to any small act. Act matlab doing something, not that piece of legislation. So Armed Forces Special Power Act is actually on paper it is not a martial law, but de facto it is a, we'll see Article 34 and then you'll understand better. Huh? Of course hoga. Army Act Section 7, Section 9, there can be inner proceedings against them if they find guilty. I can tell about 100 cases, not 100, at least 15 cases where the Supreme Court has ordered the police to register or normal English. Court has said that nobody is above law, but that is a very, many things can be said about that, but it's better that we not discuss here. Okay, so you just need to understand the powers out here. Okay, ab dekhiye, we'll see Article 34. So we'll see Article 34. Article 34 says that, now you see the language of both the okay. It says, why I am giving so much time? Normally it is not, because this time there is an issue related to that in Nagaland, so they may ask a question in mains. It says, notwithstanding anything in the foregoing provisions of this part, matlab puri fundamental right ko exempt, notwithstanding anything in this part, that is part 3, Parliament may by law indemnify, Parliament kisi ko maaf kar sakti hai, any person in service of the union or state, any union government employee or state government employee, or any other person, yani anybody who is helping the government employee, he is not even a government employee, in respect of any act done by him in connection with maintenance or restoration of order in an area where martial law was in force, or validate any sentence passed by punishment inflicted, forfeiture ordered. So there is absolute immunity to a person who is doing anything under martial law. They will not ask you to write a research paper on martial law. What all things they want you to know? First, what is the difference between martial law and national emergency? National emergency grounds are mentioned in the Constitution. Martial law grounds are not mentioned. Second, national emergency, there is a direct effect on fundamental rights. जैसे ही national emergency is declared on grounds of external aggression or war, Article 19 automatically gets suspended. Here, there is no direct bearing on fundamental rights. Ground mentioned नहीं है, direct bearing नहीं है. Third, national emergency में there can be legislative changes. Center can legislate on state list. Martial law में there is no legislative or financial changes. So national emergency is a different situation, but martial law is normally for a temporary phase. If the law and order has completely broken and the armed forces are coming to assist the local administration, it is martial law. If there is a question in prelims that martial law ipso facto, एक term सुना है आपने, ipso facto? Ipso facto मतलब by itself. मतलब for example there is a spiritual ipso facto मतलब जैसे ही ये हुआ वो हो गया अपने से. So national emergency ipso facto suspends Article 19. जैसे ही national emergency is declared on grounds of external aggression or war, Article 19 खुद बखुद suspend हो जाता है by itself. Can I make this statement that martial law ipso facto suspends fundamental rights? No. Martial law directly does not touch any fundamental rights. It directly does not touch any fundamental. Second question can be there, is there a ground mentioned related to martial law? No. No ground has been mentioned in the Constitution. यहाँ लिखा है कोई ground? Civil war या कुछ भी लिखा है? No. National emergency ka grounds are mentioned. National emergency leads to legislative, executive and financial changes in the relationship between center and state. Martial law does not lead to any legislative, executive or financial changes between center and state. And Armed Forces Special Power Act on paper is not a martial law. And what is Armed Forces Special Power Act? You saw that. It is applicable. There is a special Armed Forces Special Power Act for Jammu Kashmir. That's a different one. उसमें थोड़ा और अच्छा इंतजाम है. Okay. So there is a special Armed Forces Special Power Act for Jammu and Kashmir. Okay, leave that. But this is only for 7 northeastern states. So, very simple reason. Secessionist tendencies were there in those states. मतलब अलग होने की, इंडिया से अलग होना, नागालैंड. So there are 2 factions, Isaac Movia faction, अब वही ना, northeast. So you have northeast में you have, this is, first state is Nagaland, first state is Arunachal Pradesh, below that you have Nagaland, then you have Manipur, then you have Mizoram, then you have Tripura, then you have Assam, then you have Meghalaya, and then you have Sikkim. These are the states 1, 2, 3, 4, 5, 6, 7 and 8. All 8 states have a different problem. Arunachal Pradesh is one of the most peaceful state of India. Other than land boundary issue that we have with China, there is no issue in Arunachal Pradesh. There is no secessionist tendency, peace-loving Buddhist community. So, and tribal religion also is there. So, it is 60 में 59 seats are reserved for scheduled tribe in state legislative assembly. 59 out of 60 seats are reserved for scheduled tribe in the state legislative assembly because Article 332 says as per the population of the state. So, the population of state is in that proportion. So 59 out of 60 seats are reserved for scheduled tribe. Arunachal, you cannot paint northeast with the same color. Northeast को आप एक ही brush से paint नहीं कर सकते. Arunachal Pradesh is a peaceful state. There is no issue except land boundary issue that we have with China. Nagaland, of course, there are 2 factions, Isaac Movia faction and Khaplong faction. So Isaac Movia we had, so there is a demand of Greater Nagaland. Greater Nagaland, violence maximum is over here. Manipur, you have 3 communities, Nagas, Kukis and Meiteis. Meiteis are basically OBCs, they are not tribal. I have many friends from Meitei community also in Delhi University. So Meiteis are like, for you can say Hindu, practicing Hindu religion. They are, and you have Nagas and Kukis. So Greater Nagaland demand ho raha hai, Nagaland and some areas of Manipur. And here there is economic blockade. At times there is a conflict, inter-tribal conflict also, and there are other issues also. Getting my point? So, yahan Mizoram mein bhi and Nagaland mein secessionist tendencies to move out of India. Sorry, Manipur. Mizoram is again India's most peaceful state other than the land issue that happened few days back. It is after Mizo Accord, it is very peaceful state. There is an IIMC also there, Indian Institute of Mass Communication. It's a good state. मतलब कोई issue na violence नहीं है. Tripura, you don't have any such violence, although there are certain political frictions at times, indigenous people and certain. Assam, you have an issue. Assamese identity versus migrants. Assamese and Bengali, literature and culture and food is similar, but there is a beautiful Assamese culture also, which is absolutely separate. And there is a apprehension that Assamese, they want their separate identity to be there, and there is an influx of migrants from Bangladesh, especially in lower Assam. Upper Assam, you have Sibsagar and all these districts. Okay, so वहाँ पे issue है Assamese identity का. There is no secessionist. There is no secessionist issue as if now, although there was violence, Ulfa and all, now things have. Meghalaya, you have Garo, Khasi and Jaintia. These are tribes, जो पहाड़ है उन्हीं के नाम पे, and there was violence. Outsiders were attacked 3 years back. The outside trading community from other parts were attacked. Sikkim again is very, very peaceful state, other than the fact that it is at the tri-junction of India, Bhutan and People's Republic of China. So violence का अगर देखें तो Nagaland and Manipur predominantly or be northeast में. So there were secessionist tendencies. That is why Armed Forces Special Power Act was. Mizoram also there was a violence, but after Mizo Accord it has ended. Assam also there was a Assam Ulfa Accord that was signed. Ulfa, central government and state government. So it has also subsided. Meghalaya, there is no such secessionist issue, and Sikkim is a peaceful state. Tripura also, there is no such issue. So you cannot paint northeast with the same color. Every state has a. हाँ एक बात और. In चारों state में you have inner line permit. Inner line permit is there only in these 4 states: Arunachal Pradesh, Nagaland, Manipur and Mizoram, where Indians have to take permission to go to certain areas. So these 4 states have ILP. Manipur में latest extend किया है 2020 में, पहले नहीं था. So why? Because inner line permit areas are exempted outside the Citizenship Amendment Act. We'll see that. Okay. So the point is कि these, and there is a difference between ILP and PAP, protected areas permit. उसमें बहुत areas हैं. That is for foreigners. ILP is for Indian citizens, you and me. Okay. So Armed Forces Special Power Act में 3 sections important हैं. First, the right to declare an area as a disturbed area. Second, what are the powers once an area is declared as a disturbed area. And third, the power that is any case can only be instituted after the permission of central government. So this is Armed Forces Special Power Act, this is martial law. What is the difference? And all these things are there. Okay, so this will, and Article 35 to kuch hai hi nahi, it's very very easy. We'll see that. So we have few more we'll take. Okay, एक second थोड़ा इन लोगों. Sir, in Article 13, 1 second, Article 13, all fundamental rights are restricted or only some right. Article 33 में who will restrict the fundamental right? Who will restrict the fundamental right? Parliament. So Parliament has passed Army Act, Air Force Act, Navy Act and Police Forces Restriction of Rights Act 1966. So किस हद तक वो फंडामेंटल राइट एंजॉय करेंगे, कौन डिसाइड करेगा? पार्लियामेंट शैल डिसाइड द एक्सटेंट टू विच आर्म्ड फोर्सेस शैल बी एंजॉयिंग फंडामेंटल राइट्स. इससे ज्यादा यू दे विल नेवर आस्क, यू डोंट नीड टू नो. ओके, देन यू हैव white shirt is its own philosophy. Okay, which article of the convention child of, is it necessary to remember all the articles? nahi, bilkul bhi nahi. All the articles which are necessary you will learn by yourself. You will cover it so many times during the class that you don't need to sit down and remember. Can Article 19 suspended in internal war? nahi. I told you Article 19 automatically gets suspended only on grounds of external aggression and war. In Article 359 remedy can be suspended. अभी उतना नहीं जाएंगे, फिर एक नई कहानी. Sir, anti-conversion law and POSCO Act burden of proof. There are certain laws which is an exemption and the Supreme Court has also validated them. Sir, how we can prove that private detention is wrong? You go to the police. If the police is not taking any action, then you can file a habeas corpus petition. In certain circumstances, it is entertained against private individuals also. सही बात है. Okay, video stopped. Video stopped. This is 5:48. We are in 6:15. Okay, अब आप पूछिए क्या क्वेश्चन पूछ रहे थे. अच्छा, in declaring नहीं, कोई रोल नहीं. State is consulted. State legislature has no, state government can declare an area. State legislature has no role because the law has been passed by Parliament. And that is a matter in, I'll show you where the matter comes. List. What happened to the class? The class is located at IAPL. Seventh schedule. Okay, Ministry of External. You see 7th schedule. Now you see 2A. Okay, so we have 2A. Why the Parliament went ahead and legislated? We have to end this. Okay. Then we'll see Article 35 also, don't worry. Itna matlab they don't want you to know. Just, you see what is 2A, which was added later. Padhiye. 2A in Union list. Power of Parliament to make laws. Armed Forces Special Power Act में क्या होता है? Armed forces are deployed. Who is deployed? Armed forces is deployed. So what is written? Deployment of any armed forces of the Union or any other force to a control of Union or contingent in any state in aid of civil power. यानी स्टेट गवर्नमेंट ने हाथ कि अब हमसे ना हो पाएगा. Then it is, so who has made that law? Union list में who will make law? Parliament will make law. So can the state legislature interfere? No, state legislature cannot. And if there is a conflict, अब इतना नहीं जाएंगे, पर this is Article 355 of the Constitution says, अब चलिए बात चलिए तो 355 of the Constitution says it shall be the duty of Union to protect every state from external aggression and internal disturbance. ये कॉन्स्टिट्यूशनल ड्यूटी है सेंट्रल गवर्नमेंट की, हर स्टेट को एक्सटर्नल अग्रेशन और इंटरनल डिस्टर्बेंस से बचाना है. Although armed forces is a very complicated legal, to what extent preventive detention and many other laws, we don't need to know. We just need to know. Can I make this statement that the term martial law has been defined? UPSC will ask a very basic question. That martial law has been defined in the constitution? No. Okay. So, has martial law been imposed in India? No. Armed Forces Special Power Act is a martial law? No. It is not a martial law per se, but is very similar to martial law. So, you please write Article 34. Please write Article 34. Article 34 of the Constitution Article 34 of the Constitution provides for martial law, full stop. Then you write the term martial law has not been defined in the Constitution. The term martial law has not been defined in the Constitution. Next, ipso facto अक्सर न्यूज़पेपर में पढ़िएगा. व्हाट इज द मीनिंग ऑफ इप्सो फैक्टो? साइड में दो चार टर्म है, लिख लीजिए. ठीक है. इप्सो फैक्टो, IPSO, इप्सो फैक्टो, FACTO. ओके. इप्सो फैक्टो बाय इटसेल्फ, IPSO, इप्सो फैक्टो, जस्ट बाय द फैक्ट ऑफ इटसेल्फ. ओके. ab initio लिख लीजिए. ab initio, AB ab space INITIO, ab initio. ab initio कहते हैं from the beginning, from the initial. That is ab initio, from the beginning. So you have ipso facto by itself. Quid pro quo, QUID, quid space PRO स्पेस QUO, क्विड प्रो क्यो. ये तो बहुत ही इजी है. इसका मतलब क्विड प्रो क्यो का मतलब आई गेव यू कॉन्ट्रैक्ट एंड यू गेव मी अ पेंट हाउस इन स्विट्जरलैंड और मैनहट्टन इन न्यूयॉर्क. सो दैट इज क्विड प्रो क्यो. यानी अब इसको आप अपनी भाषा में लिखिए, जैसे भी लिखिए. मतलब आपने कुछ दिया, बदले में हमने. हाँ, सो इट इज बेनिफिट्स में, यानी गवर्नमेंट ऑफिशियल ने, the government official is extending you certain benefits for certain benefits in return. So it is quid pro quo. You can write. Okay. So these terms you will always find in newspaper. Ab initio, quid pro quo, ipso facto. ठीक है. Suo motu. Suo motu means कि suo motu means by itself. कोई आया नहीं. SHO was walking by the lane. He saw two students of Vision I is fighting. Okay. None of them are coming to SHO to take note of this offense, but he saw them fighting. He will make them understand the value of law. So it is suo motu. Basically it is used in court, judiciary. For example, अभी एक दिन पहले कोर्ट ने suo motu लिया. Yes, the Pakistan Supreme Court. Pakistan Supreme Court took suo motu of the no confidence motion. So no confidence motion that was rejected by the deputy speaker. Pakistan Supreme Court ने suo motu लेकर ruling दे दिया कि deputy speaker has done unconstitutional and said that no confidence motion. So when the court takes note of something without actually a party visiting it, it is suo motu. यानी by itself, SUO. ipso facto नहीं, ये तो ipso facto मतलब कि ऐसा हो गया. यहां तो कोर्ट ने नोटिस लिया, किसी व्यक्ति ने नोटिस लिया. कुछ हो जाना और किसी व्यक्ति का नोट करने में आसमान जमीन का अंतर है. ओके. ऐसा हुआ तो ऐसा हो गया, लेकिन कोर्ट इज टेकिंग नोट. सुओ मोटो इज मोस्टली यूज फॉर कोर्ट. फॉर अनदर एग्जाम्पल, आई विल गिव यू अनदर एग्जाम्पल. क्या वो बताइए, कुछ छूट रहा आप लोगों का? सुओ मोटो समझे? SUO MOTU, MOTTO भी लिखते हैं, MOTU भी लिखते हैं. सुओ मोटो. सुओ मोटो का क्लासिक एग्जाम्पल, a comedian tweeted against judiciary. Judiciary took suo motu of that and started contempt proceedings against the comedian. That is suo motu. So when the court by itself takes note of something without anybody complaining, it is suo motu. Getting my? And then you have sui generis. ये तो easy है. Sui generis, SUI GENERIS. Sui generis, ये मैं सिंपल लैंग्वेज में लिखा. व्हाट इज sui generis? यूनिक, मतलब एब्सोल्युटली यूनिक, डिस्टिंक्ट. Why you say that he is a distinguished personality? मतलब आम के जैसा नहीं है, वो अलग है. So it is distinguished. So it is, you are getting sui generis. Indian Constitution को कहा जाता है, it's a sui generis. Why Indian Constitution is called as a sui generis document? हाँ, क्योंकि उसमें यूनिटरी फीचर्स में है और फेडरल में. नाउ यू गो बैक टू मार्शल लॉ. व्हाट वाज द लास्ट स्टेटमेंट यू रोट? द कॉन्स्टिट्यूशन डज नॉट डिफाइन द मार्शल लॉ. देन इप्सो फैक्टो आया कैसे था? इट डज नॉट लीड टू इप्सो फैक्टो सस्पेंशन और ऑटोमेटिक सस्पेंशन. देखिए, इट डज नॉट लीड टू ऑटोमेटिक सस्पेंशन ऑफ इंटर आलिया अमंग अदर थिंग. इंटर आलिया समझते हैं? नहीं सुना है? ओके. सो इंटर आलिया नहीं समझे? यू वेंट टू बाई ग्रोसरी. ओके. सो इंटर आलिया मतलब बाई, for example, you went out to buy something. You also bought current affairs. Vijna is current affairs. So inter alia you bought current affairs. मतलब among other things you also bought current affairs. मतलब ये word use होता है कि कई सारी चीजें एक साथ है, लेकिन ये भी है. Inter alia means inter alia he went there to meet his sister. So he went there for other things also, but also to meet his sister. So that is inter alia. ठीक है. अब ऐसे तो कुछ कुछ वर्ड लेके आते रहेंगे, फिर इसी वर्ड की क्लास चलेगी, सिनोनिम्स और एंटोनिम्स. सो व्हाट वाज, इट डज नॉट लीड. आई एम मेकिंग यू राइट एग्जैक्टली व्हाट विल बी आस्क्ड इन एग्जामिनेशन. कुछ भी एक्स्ट्रा नहीं. व्हाट दे आस्क इन एग्जामिनेशन, व्हाट दे हैव आस्क्ड एंड व्हाट दे विल आस्क. इट डज नॉट लीड टू ऑटोमेटिक सस्पेंशन ऑफ फंडामेंटल राइट्स. Okay. Next you write, Parliament may indemnify. Act done by. Parliament may indemnify. Act done by. Parliament may indemnify. Act done by a government servant. ब्रैकेट में लिखिए यूनियन और स्टेट. गवर्नमेंट सर्वेंट, यूनियन गवर्नमेंट और स्टेट गवर्नमेंट. क्लोज द ब्रैकेट. और एनी अदर पर्सन in connection with restoration of public order. Okay, then you write next, in connection with restoration of public order. Next point you write, martial law is generally invoked in the situation of a civil war, is generally invoked in the situation of a civil war when the military is invited. Civil war, when the military is invited इनवाइटेड, क्यों बुलाया गया मिलिट्री को? रेस्टोर पब्लिक ऑर्डर, और किसकी मदद करेगी? टू हेल्प होम, टू एड सिविल एडमिनिस्ट्रेशन. प्लीज राइट, मिलिट्री इज इन्वाइटेड टू एड. एड का मतलब हेल्प. मिलिट्री इज इन्वाइटेड टू एड सिविल एडमिनिस्ट्रेशन. Okay, full stop. Next page you write, although I am not supposed to do OFSPA here, but still there is a means probability, so you write Armed Forces Special Power Act. Please write Armed Forces Special Power Act. Armed Forces Special Power Act is a union law with union law with 6 sections. Full stop. The section 3 of the act, A capital letter में होगा. The section 3 of the act empowers the section 3 of the act empowers the governor of a state or administrator of a union territory, governor of the state or administrator of a union territory, or the central government to declare an area as disturbed area. Okay, next you write under section 4 of the act, under section 4 of the act, for the maintenance of public order, under section 4 of the act, for the maintenance of public order, there can be death by fire, there can be death by fire / arrest without warrant for a cognizable offense, arrest without warrant for a cognizable offense, and search without warrant any premises on reasonable suspicion. Search without warrant any premises on reasonable suspicion. Okay. Next you write, this can be a statement in prelims. इसी तरीके का क्वेश्चन वो prelims में पूछ रहे हैं कि it is provided under the act that the person should be handed over to the police. So you write section 5 prescribes for handing over the arrested person, अब यही तो यूपीएससी में, यही तो प्रीलिम्स में ऐसे ही क्वेश्चन पूछ रहे हैं. आर्म फोर्सेस स्पेशल पावर एक्ट न्यूज में है ना, क्या लिखा हुआ है? टू द ऑफिसर इन चार्ज ऑफ द Nearest police station. Please write officer in charge of the nearest police station. Okay. Okay, please write next section 6 of the act. Section 6 of the act provides immunity from legal proceedings. Section 6 of the act provides immunity from legal proceedings without the previous sanction of central government. ठीक है? Now you write a case, a very important case. Please write. Naga People's Movement of Human Rights versus Union of India. Naga People's Movement of Human Rights versus Union of India. Please write Naga People's Movement of Human Rights versus Union of India. ओके, सुप्रीम कोर्ट ने क्या क्या बातें कही लिखिए. द सेंटर कैन by itself declare, the center can by itself declare an area as the disturbed area. The center can by itself declare an area as the disturbed area, but it is desirable to consult state government. ठीक है, आगे लिखिए. नेक्स्ट यू राइट, सुप्रीम कोर्ट ने कहा फोर्स जो है मिनिमल यूज कीजिए, मतलब द फोर्स शुड बी यूज्ड minimal for effective action. Please write minimal force should be used for effective action. और the most important thing क्या कहा, minimal force should be used for effective action. ACTION. ठीक है. अब what was the most important part of this judgment, point of this judgment? सबसे पहले जब भी कोई एरिया डिस्टर्ब्ड एरिया घोषित होता था, बस हो गया, एक बार घोषित हुआ फिर चिल पूरा, मतलब जब तक. सुप्रीम कोर्ट ने कहा नहीं, जब भी घोषित कीजिए हर 6 महीने पर पीरियोडिक रिव्यू करके फिर से उसको करना पड़ेगा. So I'm repeating it in English that there is no provision in the act, so periodically declare an area as disturbed area after periodic review. But the Supreme Court brought a mandate that the government shall be periodically reviewing the area, and every 6 months a fresh notification should be issued declaring an area as the disturbed area. Please write. The apex court ruled that there should be the apex court ruled that there should be periodic review. The apex court ruled that there should be periodic review of the declaration. The apex court ruled that there should be periodic review of the declaration of a disturbed area. Periodic review of the declaration of the disturbed area every 6 months. Baki, you can write a balanced answer. I will not go into that. That human rights should be respected. Getting my, you know these things, na? Huh? वो जितना you know about liberty, equality, fraternity, Article 21, 14, human right, वो तो you can write that, ना? Human rights should be restricted, हाँ? अच्छा ठीक है, 2-3 पॉइंट लिख लीजिए, लिखिए. contemporary challenges. मतलब सीधा नोट को उठाकर मेंस वाले में लिख देना है. कोई भी क्वेश्चन आपको मिलता है किसी भी क्लास में, ठीक है, किसी भी क्लास में, कहीं भी पॉलिटी में, यू हैव टू, व्हाट इज द एक्चुअल thing you should do whenever you are getting a question? What you need to do, you need to sit down first, drink a glass of water, okay, and then read the question and then study for 20 minutes. Study what has been taught in the class and also what is the static source and certain internet. Once you have studied, then you write an answer without seeing the book in a time span of 7.5 minutes. This is how you write. So little effort has to be made everywhere. Okay. Now you write contemporary challenges. A. Misuse of AFSPA has led to violation of human rights. Misuse of AFSPA. Bas. Armed Forces Special Power Act. Misuse of AFSPA has led to human rights violation. Therefore, any such misuse should be dealt with. Any such misuse should be dealt with the rule of law and no refuge. Rule of law and no refuge shall be taken under the act. No refuge shall be taken under the act for human rights violation. For human rights violation. Okay. Next you write the declaration of disturbed area should gradually be limited. Declaration of disturbed area should gradually be limited and in consultation with state government. Okay. State government. Next you write and in consultation with state government. You write the act should be better implemented in harmony with the local population and for any violation proper compensation shall be meted out. For any violation proper compensation should be given. कर दीजिए, हटाइए. Proper compensation should be given. फिर वही meted out तो मेल कर देगा. Proper compensation should be given. Full stop. ठीक है, वही बात. प्रॉब्लम सिंपल है, कंपटीशन का लेवल यहां है. You want to be at Lal Babua level and you want to swim in water of 2 feet and enjoy that I have learnt swimming and feel good. I will not allow you to feel good. I'll take you to 12 feet and then you will learn how to swim. I am not here to make you feel happy. Okay. So the point is कि जो एग्जाम का लेवल है वो, कोई सिंगापुर से जॉब छोड़कर आया है, कोई मुझे मेल कर रहा है कि सर मैं यूएस से तैयारी कर रहा हूं. आई कैन शो यू द मेल नाउ. ही इज इन यूएस फॉर 10 years. ही इज प्रिपेयरिंग फॉर यूनाइटेड स्टेट्स. ही विल कम फॉर प्रीलिम्स. ओके. सो जो एग्जाम का लेवल है वही ना. अब उसमें यू वांट टू स्विम एट लल बबुआ लेवल, so that in swimming pool you must have seen like this.
इस लेवल पे सारे स्टॉलवर्ड्स होते हैं जो सिर्फ खाली सलाह देते हैं, ठीक है, रियल वंस आर हियर, ओके. सो यू हैव यू बीन टू अ स्विमिंग पूल? ऐसे होता है ना स्लैंटिंग, यहाँ यू कैन टॉक ऑल द पीपल हु गॉसिप अराउंड अबाउट द सोसाइटी एंड एवरीथिंग हियर, एंड देन द रियल वन स्विम एक्चुअली. सो ठीक है, तो यू मस्ट बी देयर, ओके. अब बेसिक्स तो आपको पढ़ना पड़ेगा ना थोड़ा सा. आप अपने अंदर की खामी देखिए कि मुझे मेहनत करनी है, थोड़ा देखना है, चीजों को तैयार करना है खुद को. यूपीएससी मामा थोड़ी है कि अरे भगने का बात है, इजी क्वेश्चन. कौन सा बेटा, कौन सा दे मामा, ये हटाइए, ये वाला दे दीजिए, ठीक है चल. ऐसा तो यूपीएससी शैल नॉट बी डूइंग ना. सो यू मस्ट बी लाइक यूपीएससी इज नॉट मामा, ओके. आई डोंट, सो दैट इज द थिंग, ओके. सो वी विल बी डूइंग आर्टिकल 35 आफ्टर ब्रेक, ठीक है. We'll take your questions also online, warriors, don't worry. Okay, shall we start? Okay, please settle down. So we have the last article, which is article 35. Okay, it is article 35 is like ki to implement a provision you need a law. Give me 5 examples where a constitutional provision in part 3 has to be implemented by a law. Give me 5 examples where a constitutional provision has to be implemented by a law. एक एक करके बताइए, चलिए बताइए. रोडस्टर 21 ए, ठीक. क्या नाम है आपका? शशि राज. ओके, वेरी गुड. सो वी हैव शशि राज सेइंग 21A. व्हाट इज द नेम ऑफ द लॉ? जो लोग, जिन लोगों को मैं ये कह रहा हूं, to implement a provision you need a law. For example, article 21 capital letters A says every child shall be provided free and compulsory education. So free and compulsory का definition क्या है? What will be the teacher pupil ratio? The entire mandate of article 21A, you need a law. So many a times you need a law to implement a constitutional provision. So article 35 simply says, to implement these things of part 3, parliament shall make law, state legislature will not make law. यानी फंडामेंटल राइट्स को इंप्लीमेंट करने के लिए पार्लियामेंट लॉ बनाएगा, स्टेट लेजिस्लेचर लॉ नहीं बनाएगा. ये फंडामेंटल राइट्स को, विच फंडामेंटल राइट्स सर? ओके, थैंक यू. सो वी हैव, ओके, साक्षी सेनगर, राइट टू एजुकेशन. आर्या बैस इज सेइंग बॉन्डेड लेबर एक्ट. वेरी गुड. Okay, so we have article 35 says, please see, very simple. आज तक लेकिन 35 पूछा नहीं है, ठीक है, कभी भी पूछ सकता है. Parliament shall have and the legislature of state shall not have power to make laws related to any matter which is clause 3 of article 16. मतलब prescribing residence as a criteria for certain classes of employment within the state or union territory. You remember article 16? Yes. Clause 3 of, मतलब एवोल्यूशन हो गया है होमोसेपियंस का, लेकिन देर इज अ उर्दू कपलेट, तहजीब आती है आते आते, जाती है जाते जाते. एनीवेज, सो वी देर इज अ, so we have, with respect to any of the, there was a what you call that, you know, that poet thing going on, ठीक है, you call it kavi sammelan. So one person was actually giving that, what you call, apne andaz mein, he was like, who, he was doing like this. So there was a man who was actually comparing the event. He said ki everybody has a right to what you call praise in his or her own language. Okay, anyways, so it is clause 3 of the article 32. What is clause 3 of article 32? हाँ, ये तो खैर थोड़ा टफ हो जाएगा. The power of parliament to give writ jurisdiction to any, this question has been asked actually. This question has been asked that the parliament can empower any court other than Supreme Court and High Courts also to issue writs, and the parliament has empowered nobody till now. Okay, so who can issue writ? Supreme Court and High Court. तो कह रहा है कि पार्लियामेंट लॉ बनाएगा, स्टेट लेजिस्लेचर लॉ नहीं बनाएगा. Parliament shall be making laws, state legislature shall not be making laws to implement clause 3 of Article 16, clause 3 of Article 34 and martial law. And also for prescribing punishment for those acts which are declared to be offense. जिन जिन चीजों को ऑफेंस बनाया गया है पार्ट 3 में, उसमें पनिशमेंट क्या मिलेगा, व्हाट ऑल वुड बी द पनिशमेंट शैल बी डिसाइडेड बाय द पार्लियामेंट, नॉट बाय द स्टेट लेजिस्लेचर. एग्जांपल अनटचेबिलिटी, एग्जांपल बॉन्डेड लेबर, all these are offenses in part 3 and the punishment shall be prescribed by parliament. Then you have any law. अब ये सब छोड़िए, समझ गया ना इसमें, बस ठीक है. So article 35 please write. Article 35, Parliament not the state legislature. Parliament not the state legislature. Very good. Rashi Pradhan is saying, Rashi Pradhan, Prevention of Practices of Untouchability, Sohan Singh, Schedule Caste Act, very good. Nakul Verma, SC/ST Act, Narinder Pal, Kaushal Banwal and Amarjeet Kaur. And Suman, thanks Subhadeep. Okay, chaliye, likhiye. So it is the Parliament, बोलिए ना जोर से थोड़ा, not the state legislature shall make laws. The Parliament, not the state legislature, shall make laws to implement fundamental rights related to implement fundamental rights related to clause 3 of Article 16. Clause 3 of Article 16, ब्रैकेट में लिखिए. क्या लिखना चाहिए भाई इसमें? Clause 3 of Article 16, what shall we write? Prescribing residence as a criteria, please write in bracket, prescribing residence as a criteria for certain classes of employment, prescribing residence as a criteria for certain classes of employment. Within the state or union territory. Within the state or union territory. Next point you write. To extend writ powers to extend writ powers to WRIT, to extend writ powers to. अभी कौन रिट इशू कर सकता है? Who can issue writ today? Only Supreme Court and High Court under Article 32 and 226 respectively. Parliament को power दिया गया है. Parliament has been given power to extend the writ powers to any other court other than Supreme Court and High Court without curtailing the power of Supreme Court and High Court. Has the Parliament given power to any other court to issue writs? No. But the Parliament has such power, and this actually question has been asked also. So please write. क्या लिखा आपने? To any court other than Supreme Court and High Court. Any court other than Supreme Court and High Court. Okay, actually I just want to share you a very important thing. I know somebody who is preparing very diligently, and actually initially he was not working hard, but after he exhausted his attempt in all the UPSC attempts, and then he became serious in life. Okay, and after a certain age you cannot take money from your parents, and that is a bit disappointing. So but he started preparing very diligently for past 1 year. So now the results have come of state PSC interview, so he has been invited for interview, and hopefully he will make it. So of course there is not a single, I have not seen a single person who has not left the race, has not actually cleared it. So I am very, very happy, because I was extremely worried about that person. So he has been preparing diligently. Abhi 1-1.5 saal pehle his self-respect got a bit, I have wasted my attempts and I was not studying, and he was too much into socializing. Now he has been invited for interview call with mathematics optional. So actually that's and he'll get selected. So finally, whenever you jab jage tab
So he messaged me, he got the result and he messaged me. So this is something which is something. So you must, if you are never think about the result, you give your best. Okay. So next point you write. अब इस पे मुझे last काम होगा दुनिया में, मैं ज्ञान दूंगा इस पे कि सब माया है, all this. So हाँ क्या लिखा? हाँ bracket other than Supreme Court and High Court, without curtailing the jurisdiction of Supreme Court and High Court. Without curtailing the jurisdiction of Supreme Court and High Court. Okay. Curtailing the jurisdiction of Nikhil Avasthi, I attempted UPSC CDS 2022. All the questions of polity I have attempted are correct just because of you. Thank you so much. Okay. ठीक है चलिए. So it is, next you write, any law related to martial law, any law related to martial law shall only be enacted by the parliament. Okay. Shall only be enacted by the parliament. Okay. Now you see the language and then you will say directive. सबसे पहले इसको मेंस का लगातार 4 साल 37, 38, 39, 40 37, 38, 39 back to back 4 years they have asked question from article 36, article 37, article 38 and article 39 back to back. एकदम एक chronology है. I told you at the onset when I morning batch में मैं बता रहा था कि कुछ भी नहीं देखना है, सिर्फ यूपीएससी के प्रीवियस ईयर्स देखना है. The best guide is UP, everything comes second. Any test series, anything will be second. First, what you need to do, you need to go through the previous year's paper of UPSC. और मेरे हिसाब से तो hard copy, ठीक है? So you get a decent hard copy, sit down with yourself, you and yourself, and go through previous year's question paper, see what kind of questions. I wish I had time. I have the paucity of time. Within limited time I have to do so many things and we have just started. Otherwise I would show you that how they have lifted questions from previous years, what you call previous years ke question se option se next year ka question. They asked a question that who is the chairman of Civil Services Board? Cabinet Secretary. He is the highest civil servant at the country level. Next year उन्होंने question पूछा who Chief Secretary पे. So पहले पूछा Cabinet Secretary, next year Chief Secretary. First year they asked the question on Article 38, second year they asked on Article 39. First, back to back. First year they asked the question that Council of Ministers are collectively responsible to Parliament. एक जगह next year उन्होंने पूछा collectively responsible to legislature. So the best guide that should help you, believe me, is previous year's question paper. Previous year's question paper पे research कीजिए और देखिए pattern क्या है. UPSC follows a pattern. And if possible, you can go through CDS and CAPF question papers also. I have seen that they have lifted questions from there also. So CDS and CAPF का भी जो question है, जो UPSC 2 और exam कराती है, ऐसे तो geologist services, economic services, so many exams. But Central Armed Police Force का जो ITBP, CISF, CRPF और CDS के भी papers कभी अगर UPSC की तैयारी जब कीजिएगा, so you get time. So you briefly go through that also. Okay. UPSC follows a pattern. I know they follow a pattern. They asked the question on cases in CAPF January में 2000. Similar question was asked in prelims. So please go through previous year's question paper before anything else. That is very, very necessary. Now we see directive principles of state policy. हाँ पूछिए. See. First of all, right to adequate livelihood is one of the provisions in Article 39 also and 41 also. Indirect hint is there. Okay. Supreme Court has not ruled directly that right to livelihood. People's Union for Civil Liberties case में Supreme Court ने कहा payment of wages less than minimum wages act is violation of livelihood and Article 21. So, and everybody in one of the cases related to a state government, Supreme Court said everybody has a fundamental right to access basic minimum food.
So right to livelihood is one of the provisions that we will see in directive principles of state policy. Directly in People's Union for Civil Liberties case mein, non-payment of wages or payment of wages less than MW, Minimum Wages Act, is also a violation of Article 21. This is the classic position. Huh. Hmm. सी एकदम सिंपल है, इसका आंसर यहीं छुपा है, प्रोस्टिट्यूशन, क्योंकि किसी ने पूछा भी था. ओके किसी ने पूछा भी था. वी विल डू सिटीजनशिप इज ओनली वन थिंग दैट आई डू एट द एंड. वील डू, डोंट वरी. We'll do citizenship, Union Territory, Jammu Kashmir citizenship. That is the only thing that we'll do at the end. I'll tell you why right to. I'll answer your question. Just a second. Prostitution पे इसी बैच में किसी ने और भी पूछा था, ठीक है? Okay, so Article 19(1)(f) gives you fundamental right to practice any profession or carry out any occupation, trade or business. ठीक है? But you have a fundamental right to practice any profession. Does that include prostitution also? Supreme Court says that the what you call Immoral Trafficking Act or any such act which prohibits soliciting clients for that will lead to, can be legislated because it is against the general public. So Article 19(1)(f), fundamental right to practice any profession, can be restricted in the interest of general public. And general public ke interest mein prostitution is morally not permittable. That is why this is not a fundamental right or any right to practice. Even to the extent Supreme Court has ruled, I actually don't remember the case honestly, so I should not, ki movement of AIDS patient and prostitutes can be restricted by the state. Their movement can also be restricted. Huh. Huh? Okay. So actually, Babu, ये तो moral issue है ना. This is a social issue. This is not a policy. See, polity में any women who is forced into what you call prostitution or anything, it is immoral trafficking. That is covered under Immoral Trafficking Act. But this first question, that whether right to prostitution is a fundamental right to practice any profession, Supreme Court says that it is against the interest of general public. Now you are raising a social issue ki a child born, because this is a clear thing. No child is illegitimate. So you are raising an issue. What about the children? Their right to? Already engaged in that. So yes, if they are forcefully engaged, okay. So that is an offense. That is an offense, na? So Immoral Trafficking Act, that is an offense. So what is the question? Bataiye. So it is an offense ho gaya. It is an offense. Anybody who forces them, or even there is a, their movement can be cutted. Simple language mein, prostitution is not a fundamental right under Article 19(1)(f). So it is not a thing that is permissible in India. This has been ruled time and again. Ki soliciting clients or any such favor is not a, although I don't want to, but there are other judgments of Delhi High Court also, what constitutes prostitution, it's a different thing, but this is not a right. Ab ye social issue hai na bhai. This is a social issue. That social issue is something which is a fact. Many things, child labor. Supreme Court has declared child labor as what you call violative, but is there not child labor in India? So that's a social issue, okay. So we can talk about that for 2 hours, but no point. कोई उसका कोई मतलब ही नहीं है, okay. बताइए, पूछिए. Of course not. Of course not. First, you can only go to Supreme Court. First of all, Supreme Court will reject that petition. You can only go if Supreme Court has accepted certain petitions against untouchability against private individual in certain cases. If there is a systematic untouchability that is being practiced by a particular community, then you can go to, and the state is not doing anything. First thing is you will go to state. And there is a Mandir Marg police station, Karol Bagh police station, Old Rajendra police station, and there is SC/ST Prevention of Atrocities Act 1989. And then first you will approach them. If the state is not taking any action, then you will go to, of course, under SA Article 17, it is applicable against private individual only if the court allows. If there is a community that is systematically, ye court ka discretion hai, because fundamental rights are available against the state. They have entertained petitions in certain circumstances against private individuals, of course, under Article 17. Habeas corpus bhi entertain kiya hai, but that is the discretion of court. First, you will file a case under Protection of Civil Rights Act 1955 and SC/ST Act 1989. Otherwise, jitna untouchability ho raha hai, everybody will go to Supreme Court, and there are 73,000 cases pending, 7 lakh ho jayega. So, of course, that is not permissible, until, and the court will not. बोलिए, ये सब actually कुछ क्वेश्चन ही, मतलब यूपीएससी, हाँ बोलिए. NRIs. Income Tax Act 1961 says anybody who stays outside India for 182 days or more in a financial year is NRI for taxable purposes. And NRI is like you and me, an Indian citizen. Without an iota shadow of doubt, वो हमारी और आपकी तरह एक इंडियन सिटीजन है. सेक्शन व्हाट यू कॉल इनकम टैक्स एक्ट 1961 कहता है कि सेक्शन 11 आई थिंक कि एनीबडी हु इज आउटसाइड इंडिया फॉर 182 डेज और मोर इज नॉन रेसिडेंट इंडियंस फॉर टैक्सेबल पर्पसेस. ही इज प्योरली एन इंडियन national like you and me. And Representation of People Act 1950 as amended says any NRI can get himself enrolled at the place that is printed on his passport. जो भी passport पे printed address है, he will get himself enrolled with the voter list of that place, but on the day of election he has to be physically present. And 25,000 Indians flew from outside across the world to vote in 2019 elections. In December 2020, for the first time, Election Commission of India wrote to the Ministry of Law and Justice that we are electronically and administratively and technically ready to extend ETPBS, electronically transmitted postal ballot system, to the NRIs. लेकिन अभी scheme implement नहीं हुई है. They are like you and me. They are Indian nationals. Okay, so they are Indian nationals. हाँ. हाँ. A prisoner of war, of course, he will be an enemy alien because we are at war with that guy. So he will not enjoy the rights under Article 22, first part. But Abhinandan was not a prisoner of war. War was not declared between India and Pakistan. Of course, he was taken because there was an attempt. Okay, so what is the provision in their constitution? It is there. We did not declare a war on Pakistan. हाँ, बिल्कुल. Without a shadow of doubt, he will get that protection under Article 22 because he is a friendly alien, not an enemy alien. So he is asking about friendly alien, whether he'll get under preventive detention. Yes. Then he is asking about prisoners of war. If we have, he will be an enemy alien. और पूछिए जल्दी पूछिए. हाँ हाँ. If a person who, India is at war with Afghanistan. No, we have sent humanitarian aid. So he will get a protection under Article 22. Habeas corpus, Article 32. Preventive detention has a different relationship with habeas corpus. Habeas corpus petition can be filed if preventive detention. सुनिए, बहुत ही आपने अच्छा क्वेश्चन पूछा. एक लाइन मैंने लिखवाई थी. Habeas corpus cannot be filed. ये क्वेश्चन दूसरी बार पूछा गया है इसी बैच में. Habeas corpus cannot be filed if the detention is. You just go and see. I have made you write. Habeas corpus is Lawful, LAWFUL. So preventive detention is under a law. तो वो नहीं एप्लीकेबल होगा ना प्रिवेंटिव डिटेंशन. हाँ नहीं करेंगे ना बिकॉज दोज राइट्स आर नॉट अवेलेबल. सुनिए एक बस इन्होंने तीसरा जो क्वेश्चन पूछा दैट इज मोस्ट इंपॉर्टेंट क्वेश्चन विच ही हैज आस्क्ड. हेबियस कॉर्पस पिटीशन कैन नॉट बी फाइल्ड व्हेन द डिटेंशन इज लॉफुल. अगर लॉफुल ये मैंने लिखवाया है आपको व्हेन द डिटेंशन इज लॉफुल और प्रिवेंटिव डिटेंशन लॉफुल है क्योंकि एसएचओ को मन किया तो प्रिवेंटिव डिटेंशन नहीं होगा. इट विल बी डन अंडर नेशनल सिक्योरिटी एक्ट. So preventive detention is also under a provision of law and any detention under law is lawful. So preventive then habeas corpus. हाँ अब you are challenging the very detention is illegal. अब इसमें एक legal point है अब मैं नहीं जाऊंगा पर ठीक है चलिए इतना याद रखिए. हाँ अब ऐसे तो फिर चल बोलिए चलिए बोलिए we can discuss after the class. जल्दी बोलिए. Any law? Okay, inconvenient with legal right but not fundamental right. Can we go to Supreme Court? Can we go to? No, we cannot go to Supreme Court. इसीलिए right to property was deleted and it was put under Article 300 capital letters A. Until High Court जाइए 226. High Court Supreme Court का 32, High Court का 226. Okay. सुनिए डायरेक्टिव प्रिंसिपल ऑफ स्टेट पॉलिसी आई वांटेड टू स्टार्ट. ओके देयर इज ओनली वन थिंग विल स्किप दैट इज सिटीजनशिप. बट बिफोर डायरेक्टिव प्रिंसिपल्स ऑफ स्टेट पॉलिसी आई हैव गॉट एम्पल ऑफ ईमेल्स ऑन मेजॉरिटी. मेजॉरिटी इज समथिंग विच इज कॉमन विच विल बी एप्लीकेबल एवरीवेयर. वो नमक है जो सारे खाने में जाएगा. वी हैव डन आर्टिकल 13 मेजॉरिटी, कॉन्स्टिट्यूशन अमेंडमेंट मेजॉरिटी. सो वी विल डू टाइप्स ऑफ actually it is done right after the introduction class, but now we'll do types of majorities rather than starting directive principles of state policy. From which question paper? Okay, you're getting, or we should start directive principles. चलिए मुझे कुछ नहीं, मुझे मेल करते रहते हैं कि सर मेजॉरिटी नहीं कराया. Okay, now this is one of the favorite topics. Okay, first directive principles of state policy. What is the language of this thing? That is the directive principles मतलब जो भी सरकार सत्ता में रहेगी वो एग्जीक्यूटिव एक्शन और लॉ बनाने से पहले इन आदर्शों का ख्याल रखेगी. यानी इफ यू आर, दिस इज मोस्ट इंपॉर्टेंट फॉर गवर्नेंस. Article 37 of the Constitution says directive principles are fundamental for governance. So whenever you are writing an answer in governance GS paper 2, you will also talk about directive principles of state policy. क्योंकि पूरे Constitution में अगर कहीं भी लिखा हुआ है कि these principles are fundamental for governance anywhere in the Constitution, it is Article 37. Article 37 says these principles are non-justiciable. Nevertheless, they are fundamental for गवर्नेंस. यानी कोई भी सरकार सत्ता में रहे इन आदर्शों का, इन उसूलों का. एंड देन द व्हाट यू कॉल, मिस्टर नेहरू सेज दैट डायरेक्ट फंडामेंटल राइट्स आर इन्फोर्स्ड इन कोर्ट ऑफ पीपल. डायरेक्टिव प्रिंसिपल्स आर इन्फोर्स्ड इन फंडामेंटल राइट्स आर इन्फोर्स्ड इन कोर्ट ऑफ लॉ. डायरेक्टिव प्रिंसिपल्स आर इन्फोर्स्ड इन कोर्ट ऑफ पीपल. If a government fails or neglects or ignores directive principle, it will be thrown out of power after 5 years. So governance जब होगा तो हमेशा इन उसूलों का ध्यान रखा जाएगा. Now we'll see what all things are there. First you understand directive principles. The Constitution of India is directing the government कि these principles should be kept in mind by the state while making policy. जब भी state policy बनाएगा तो इन उसूलों का ध्यान रखेगा. So let's understand. First of all, directive principles are non-justiciable. Why? Dr. Ambedkar answered this. Many of the members of Constituent Assembly were very excited. कि now that we have got independence, let's make everything fundamental right. Maternity benefit, fundamental right. Village panchayat, fundamental. Part 3 में डालते हैं. Dr. Ambedkar said, a nation that has just awakened from colonization for 200 years does not have the economic capacity to implement
such things. Everybody will move tomorrow to give maternity benefit from where the state. 39 villages in India had electricity. Average life expectancy was around 33 years. So, क्या हो जाएगा? कहां से पैसा आएगा? So, you are getting my point now. So, Dr. Ambedkar said, this is Mr. Ambedkar's statement, that we will leave upon the future government to decide the time and place of implementing directive principles of state policy. अब आप मुझे एक छोटा सा एग्जाम्पल देता हूं, then you will understand. Village पंचायत, maternity benefit, ठीक है? Then you have separating a judiciary from executive, or for that matter right to work, or differently abled के rights को protest करना, or you have what you call this early childhood care, protecting the interest of SC, ST and weaker sections. Okay, and you see right to practice your religion, अपने मजहब को, freedom of speech and expression, right to be treated equally, equality before law, abolish untouchability, freedom of speech and expression, right to be travel throughout the country, or no ex post facto law. ये सारा फंडामेंटल राइट है और ये सारा डीपीएसपी है. किसको इंप्लीमेंट करने में पैसा लगेगा? Here you don't need a single rupee. To abolish untouchability, you have to end a practice. To treat everyone equally, you have to make a provision. To allow everyone to speak, you don't need to spend money. To allow everyone to follow their religion, you don't need to spend money. To not retrospectively apply a criminal law को retrospectively apply नहीं करने के लिए कोई पैसे की जरूरत नहीं है. Directive principle to establish village panchayat, you need money. To extend maternity benefit to women, you need money. To provide for early childhood care, you need money. To give people work, you need money. To provide for all these things, SC/ST welfare, you need money. So all these things in DPSP you need money. So Dr. Ambedkar said, भावना में मत बहिए और इस बात को समझिए कि a nation that has just awakened after 200 years of colonization, we will leave upon the future governments to decide the time and place of implementing directive principles. And rights were classified into two parts. Rights को दो भाग में classify कर दिया गया. One part, those rights which are justiciable, जो सुप्रीम, if they are not implemented, you can go to Supreme Court. Next, government पे छोड़ दिया, वो implement करे या नहीं. Now you see, we'll start DPSP. First you see the background. What the government has done in all these years. जैसे जैसे the economic capacity of Indian state increased, जैसे जैसे Indian state के पास पैसा आता गया, you see Article 40. Village पंचायत, constitutional amendment करके Article 243, Part 9, you have made it a constitutional compulsion. किया ना implement village पंचायत. फिर गवर्नमेंट के पास पैसा आया, महात्मा गांधी नेशनल रूरल एम्प्लॉयमेंट गारंटी एक्ट करके उन्होंने राइट टू वर्क 100 डेज ऑफ अनस्किल्ड मैनुअल लेबर. फिर पैसा आया मैटरनिटी बेनिफिट एक्ट, 26 वीक्स ऑफ मैटरनिटी बेनिफिट टू विमेन. देन यू हैव अर्ली चाइल्डहुड केयर के लिए मिशन इंद्रधनुष, बच्चों के लिए यूनिवर्सल इम्यूनाइजेशन प्रोग्राम. SC/ST के लिए यू हैव हॉस्टल, स्कॉलरशिप, रेसिडेंशियल प्रोग्राम, सो मेनी थिंग्स. सो ओवर द पीरियड ऑफ टाइम जैसे जैसे सरकार के पास पैसा आता गया वो इंप्लीमेंट किया. एंड मोस्ट इंपॉर्टेंटली आर्टिकल 21A, राइट टू एजुकेशन. इन मोहिनी जैन केस सुप्रीम कोर्ट सेड राइट टू एजुकेशन अप टू ग्रेजुएशन लेवल. देन दे थॉट नहीं, इट इज प्रैक्टिकली नॉट फीजिबल. जेपी उन्नी कृष्णन केस में बोला अप टू सेकेंडरी लेवल. सो द पॉइंट आउट हियर इज कि स्टेट ने आर्टिकल 45 में अर्ली चाइल्डहुड केयर एंड एजुकेशन इन द एज ग्रुप 0 to 14 को, वहां 0 to 6 इज देयर, 6 to 14 इज फंडामेंटल राइट. सो जैसे जैसे स्टेट के पास पैसे आए, स्टेट की इकोनॉमिक कैपेसिटी बढ़ी, तब तब स्टेट ने, whenever the state's economic capacity rose, it has made those directive principles as implemented, and they are beautifully implemented. Okay, so directive principles are those principles which must be kept in mind while making a policy. Policy can be in the form of law or it can be an executive. For example, National Rural Livelihood Mission, law थोड़ी है, एक policy है. स्वच्छ भारत. Then you have Mahatma Gandhi National Rural Employment Guarantee Act, law है. Maternity Benefit
एक्ट लॉ है. सो मिशन इंद्रधनुष एक स्कीम है. सो देर इन वॉट एवर वेज द स्टेट इज एक्चुअली इंप्लीमेंटिंग डायरेक्टिव प्रिंसिपल्स ऑफ स्टेट पॉलिसी, जब स्टेट के पास रोकड़ा आना शुरू हो गया. सो डॉक्टर अंबेडकर सेड लेट्स लीव अपॉन द फ्यूचर गवर्नमेंट्स टू डिसाइड. इमेजिन राइट टू एजुकेशन ऑन 26 जनवरी 1950. Everybody will move Supreme Court for right to education. Everybody will move Supreme Court for maternity benefit. So it will be impossible to implement. The state has a limited economic capacity. So rights were divided into two parts. Next is Gandhian principle, liberal intellectual principle, socialist principle. Constitution में ऐसा कुछ भी नहीं लिखा हुआ. This is written in Lakshmikant, basically. Okay, so constitution has not made any demarcation. Many of the principles are both Gandhian and socialist. For liberal, for example, what you call in health should be taken care of. Okay, so it has an element of socialist, to an extent liberal intellectual also, and uske baad intoxicating drink should be banned. So it is a Gandhian principle. So certain principles are both Gandhian and so you cannot, constitution ने बच्चों की तरह demarcate नहीं किया कि this is a Gandhian principle, but yes, for convenience we have classified so that we end up having a clear idea, and UPSC asks this question which is a Gandhian principle and all these things. Before we start directive principle, एक line मुझे याद आई. Constitution of India is equipped with tools of social revolution. Constitution of India is equipped with tools of social revolution. It is referring to directive principles of state policy. अगर constitution में ऐसे tools हैं जो सामाजिक क्रांति ला सकते हैं, it is direct. Don't you think that if India completely what you call implements DPSP, India will become Switzerland? So getting my point. So अगर पूरे DPSP को implement करे तो यूटोपियन स्टेट हो जाएगा. There will be a village पंचायत, right to work, maternity benefit, people would have health facilities. So you are getting my point. So directive, uniform civil code, early childhood care, SC ST, मतलब it is a long journey. Okay. So और सुप्रीम, चूंकि डायरेक्टिव प्रिंसिपल्स ऑफ फंडामेंटल राइट में क्लैश स्टार्टेड फ्रॉम 1951. डायरेक्टिव प्रिंसिपल सेज avoid concentration of wealth, minimize inequalities in income. When you go to take the land from the zamindar, he goes to Supreme Court that my fundamental right to property is being violated. So fundamental right or DPSP में constant clash. First Supreme Court said कि Sajjan Singh case fundamental rights have a supremacy over directive principle. Later on 1980 में हमेशा के लिए कह दिया the Constitution of India is resting on the harmonious balance between fundamental rights and DPSP. ये सुप्रीम कोर्ट कह रहे हैं, and this will be given you. This is Vision's favorite mains question. They'll give you that the Constitution of India is resting on a harmonious balance between fundamental rights and DPSP. So directive principles एक इतना इंपॉर्टेंट है. क्यों इतना? यूपीएससी फंडामेंटल राइट्स पूछे ना पूछे, डीपीएसपी जरूर पूछता है. क्यों? वाई दे आस्क डीपीएसपी? आप क्या कीजिएगा जाकर वहां? इंस्टाग्राम वीडियोस के बाद कुछ तो करने बैठिएगा. हाँ, देन यू विल डू गवर्नेंस. सो यू शुड नो what is the mandate of constitution related to governance. So they may miss fundamental rights, but they will never miss any year that is directive principle, because आप लोग को recruit कर रही है सरकार, not for your insta pics but for your governance. So directive principles are those usul, adarsh, ideology, principles that should be kept in mind while the state makes policy. सबसे important काम क्या है? When I say the state should keep these things in mind while making policy, पहला चीज क्या आता है दिमाग में? Who is the state? You must say ना, it is हल्दीराम, और बताना पड़ेगा ना स्टेट क्या है. The directive principle will be implemented by Mr. X. So I should tell now who is Mr. X. So Article 36 of the Constitution, that is the first directive principle, कुछ नहीं, simply कहता है the definition of state in part 3 shall be applicable to part 4. So part 3 में किस article में था? 12. So same definition shall be applicable to part 4. और we'll start from Article 38. बहुत ही अच्छा article है. To understand the Constitution, directive principle is very important. Article 37 भी कुछ खास नहीं कहता है. कहता है these principles are non-justiciable.
मतलब if directive principles are not implemented, you cannot go to court. आप कोर्ट नहीं, जब सरकार के पास पैसा होगा, when the government will have economic capacity, वो implement करेगा. They are non-justiciable yet fundamental for governance. So first, let us see we'll write a comprehensive introduction of DPSP and Article 36 and 37. We cannot start today. So first, let us see Article 36 and 37. Okay, so Article 36 and 37. You are getting, and ab ye to, you know, directive principles have been borrowed from. This was actually a question in class first. That directive principles have been borrowed from Irish Constitution. Content bhi wahin se liya hai. Concept of DPSP has come from Ireland. Content, village panchayat hai wahan. So content of DPSP is sui generis, that is Indian. But the concept of DPSP has come from Irish. Wahan village panchayat kahan? Uniform Civil Code. Weaker sections. So that is, what is Article 36? You see, it is written in English. It says, in this part, which part? Part 3? Acha, part 4. Okay? In this part, that is part 4, unless the context otherwise requires, the state has the same meaning as in part 3. Yani definition of state jo fundamental right mein hai, ye question UPSC, this is actually a lalbabua question, where they ask ki the definition of state in part 3 shall be same as part 4. Samajh rahe na? Article 37 says, the provisions contained in this part, that is part 4. What is the name of the part? DPSP. Shall not be enforceable by any court. Yani these principles are not non-justiciable, but the principles therein laid down, लेकिन जो इसके अंदर उसूल दिए गए हैं, are nevertheless, मतलब ऐसा बिल्कुल भी मत समझिए, fundamental in governance of the country. ये देश चलाने के लिए सबसे fundamental मतलब सबसे important usul hai. These are the fundamental principles to run the country, and it shall be the duty of every state. It shall be the duty of every state to apply these principles in making laws. So whenever the state shall be making laws, these principles shall always be kept in mind. So if there is a statement, ab directive principle se kya kya question aaya hai, wo sab dekhte hain. They have asked that fundamental, which of the following parts mainly promote social and economic justice? So it is DP. अब ये सब तो I take you to, and you, they are asking this question, which part, directive principles are non-justiciable. Okay, they are nevertheless which of the following part are nevertheless fundamental for governance? Which of the, so these are the questions which UPSC is asking, and DPSP से और fundamental rights से तो question गलत हो ही नहीं सकता, until they are asking a question on article liberty. Liberty, they take the liberty to interpret liberty. Many times they give two statements absolutely correct. Otherwise, isse to sawal, God forbid, but most of the chances you'll make a correct statement. So you write a beautiful introduction on DPSP. Please write directive principles of state policy. The concept of DPSP, I use the term inspired. Kyun likhe borrow? The concept of DPSP have been inspired from Irish Constitution. Then you write, they are non-justiciable. They mainly promote social and economic democracy. They mainly promote social and economic democracy and justice. Okay, I'll answer your question, Nikhil. Don't worry. Please write in the words of Granville Austin, Gran G-R-A-N, V-I-L-L-E. In the words of Granville Austin, Granville, Granville Austin, A-U-S-T-I-N. Okay, Granville Austin. The Constitution of India is equipped. The Constitution of India is equipped. Equipped समझते ही है. The Constitution of India is equipped with tools of social revolution. Which tools of social revolution? Okay, next you write. अब बहुत सी बातें हैं, लिखिए. Directive principles are this question actually has been asked कि एकदम basic question, similar to instrument of instructions of Government of India Act 1935. सुनिए, एक लॉ है जिसका नाम है गवर्नमेंट ऑफ इंडिया एक्ट 1935. देयर इज अ लॉ. उसमें देयर वर सर्टेन इंस्ट्रूमेंट ऑफ इंस्ट्रक्शंस कि गवर्नमेंट ऐसे काम करेगी. द गवर्नमेंट विल वर्क लाइक दैट. सो डायरेक्टिव प्रिंसिपल्स आर सिमिलर टू दिस क्वेश्चन हैज बीन आस्क्ड इंस्ट्रूमेंट ऑफ इंस्ट्रक्शंस इन गवर्नमेंट ऑफ इंडिया एक्ट 1935. प्लीज राइट. डायरेक्टिव प्रिंसिपल्स आर सिमिलर टू इंस्ट्रूमेंट ऑफ इंस्ट्रक्शंस ऑफ instrument of instructions of what? Of Government of India Act 1935. अब लिखिए, the Supreme Court in Minerva Mills case. The Supreme Court in Minerva Mills case ruled that this will be given in your, because this is a very important question. This question has been asked many times. Ruled that, क्या rule किया? कि क्या rule किया? Right to education. हाँ? DPSP is, हाँ? एक एक करके प्लीज बताइए. कॉन्स्टिट्यूशन रेस्ट ऑन द हार्मोनियस बैलेंस बिटवीन, यानी डीपीएसपी को ऐसा नहीं नॉन जस्टिसिएबल है, मतलब नहीं कमाता है तो उसको भाव मिलेगा ही नहीं, दोनों को इक्वल भाव. प्लीज राइट. रूल दैट द कॉन्स्टिट्यूशन रेस्ट ऑन द हार्मोनियस बैलेंस बिटवीन Constitution rests on the harmonious balance between fundamental rights and DPSP. So simply Supreme Court का क्या कहना है इसमें कि you cannot ignore DPSP and there should be a balance between fundamental rights and DPSP. Next लिखिए, the directive principles are not subordinate to fundamental rights. A.K. Thakur case. Directive principles are not subordinate to fundamental rights. ब्रैकेट में लिखिए A.K. ठाकुर केस. अब लिखिए इन नेक्स्ट लाइन में लिखिए, इन पश्चिम बंगाल खेत मजदूर समिति, इन पश्चिम बंगाल खेत मजदूर समिति, पश्चिम बंगाल खेत मजदूर समिति केस सुप्रीम कोर्ट रूल्ड दैट इन पश्चिम बंगाल खेत मजदूर समिति, you know the spelling of खेत मजदूर and all, okay? So many of you like who just had 3 BHK in Manhattan, New York suburb. So, like you say, 26. What is this? Okay. So, in Pachim Bengal, Khet Mazdoor Samiti, there are many other jokes also on this line, but anyways, the Khet Mazdoor Samiti case, nobody is, Supreme Court ruled that the role of state, is that of welfare one. The role of state is that of welfare one. Both the role of state is that of welfare one, both at center and state level. At center and state level. Next you write, the Supreme Court in Olga, ये भी एक important case मैं मानता हूं. The Supreme Court in Olga Tellis case, the Supreme Court in Olga Tellis case ruled that DPSPs are fundamental for governance. DPSPs are fundamental for governance. एक लास्ट केस लिखिए, इन स्टेट ऑफ केरला वर्सेस एनएम थॉमस. इन स्टेट ऑफ केरला वर्सेस N.M. Thomas. In state of Kerala versus N.M. Thomas, the Supreme Court ruled that the fundamental rights and DPSP must be construed in harmony. The fundamental rights and DPSP must be construed. मतलब understood. मतलब interpreted. मतलब समझना. Must be construed in harmony. एक और केस लिखिएगा, लिख लीजिए. इन जेपी उन्नी कृष्णन केस, जेपी उन्नी कृष्णन केस, जेपी उन्नी, मेजर संदीप उन्नी कृष्णन, you have heard about Unni Krishnan. In JP Unni Krishnan case, the Supreme Court ruled that FR and DPSP complement each other FR and DPSP complement each other rather than being exclusionary. Rather than being exclusionary. Okay. ये तो बचपन से सुने हैं. What does that mean? फ्री, ठीक है, फ्री मार्केट. ओके, सो एक सिंपल लैंग्वेज में लीव इट अलोन. मतलब क्या, मतलब मर्जी क्या है? नो, जैसे इज इंडिया स्टेट इज इंटरफियरिंग. गिव मी 5 एग्जांपल्स ऑफ स्टेट इंटरफियरिंग इन द मार्केट. अच्छा, एक एक करके आप बताइए. गिविंग सब्सिडीज, आप बताइए. imposing taxes, ओके. आरबीआई कंट्रोलिंग फॉरेन एक्सचेंजेस. चलिए, रीड नीर इन्होंने सही बोला. और बोलिए, ये मैं सोच भी. कंट्रोलिंग द, ओके, फूड ग्रेन. सेबी स्टॉक मार्केट, सेकेंडरी मार्केट को कैसे कंट्रोल करती है सेबी? एमएसपी, मिनिमम सपोर्ट प्राइस तो खरीद रहा है सरकार. ओके, फर्स्ट ऑफ ऑल, वेरी सिंपल. देयर वाज अ मैन, एडम स्मिथ. He said that the market should be run by invisible hands. इनविजिबल हैंड मतलब व्हाट इज द प्राइस ऑफ दिस पेंसिल शैल बी डिटरमाइंड बाय डिमांड एंड सप्लाई, इट शैल नॉट बी डिटरमाइंड बाय आउटसाइड. उसके बाद क्या हुआ? हु वाज द सेकंड इकोनॉमिस्ट? कार्ल मार्क्स ने 1848 में कम्युनिस्ट मैनिफेस्टो लिखी अपने दोस्त फ्रेडरिक एंजल्स के साथ. उन्होंने कुछ और ही बात कही, कहा हैव्स एंड हैव नॉट्स. एंड कम्युनिस्ट मैनिफेस्टो में दूसरी बात कही, द वर्ल्ड इज डिवाइडेड इनटू बुर्जियोसिस एंड प्रोलिटेरियट्स, द वर्किंग क्लास एंड द capitalist, and you sell your liberty for certain amount of money and then you buy product from his shop only. So वो different बात है. उसके बाद आए 1929 में क्या आया? ग्रेट डिप्रेशन. सो दूसरे इकोनॉमिस्ट, द सेकंड इकोनॉमिस्ट जॉन मेवर्ड कीन्स, ही सेड कि भैया इफ द मार्केट इज लेफ्ट इनटू इनविजिबल हैंड्स देन गरीबों का कुछ नहीं हो सकता. स्टेट शुड एक्टिवली इंटरवीन इन द मार्केट टू टेक केयर ऑफ द वीकर सेक्शन. सो जॉन मेवर्ड कीन्स वाज अगेंस्ट द फुल इनविजिबल. अब इंडिया में लेजिस फायर स्टेट पे आएंगे, डीपीएसपी पे. When you travel from Delhi to Lucknow, what is written on the ticket? हाँ, आपकी यात्रा मंगलमय हो. It is written that, it is written क्या लिखा रहता है टिकट? It is, please note, 41% of your travel cost is borne by government of India. यानी दिल्ली से लखनऊ जाने का जो भी किराया है, अभी पता नहीं लिख रहा है कि नहीं, लिखते ही होंगे, हाँ, उसका 41% सरकार दे रही है. यानी द प्राइस इज नॉट मार्केट डिटरमाइंड, इट इज इंटरफियर्ड. सेकेंड एग्जांपल, कोरोना वायरस की वैक्सीन गवर्नमेंट ने फिक्स कर दिया, इससे ज्यादा कोई हॉस्पिटल नहीं. सो इन इंडिया वी डू नॉट हैव लाइसेंस फायर इन एवरी एस्पेक्ट. द प्राइस इज नॉट डिटरमाइंड बाय मार्केट फोर्सेज. नाउ कम हियर, DPSPs are against laissez-faire or they are in favor. So we have Mehak Sani, foreign exchange, Mahima railways, service tax, Rashi, PSU, price determined, Renuka, Abhinav, Ishita, Varun, let it be. Okay. Less restrictions. Okay. FOMO. Anyways. So you have laissez-faire lease. Is DPSP promoting this or nahi? If there is a, अब मैं इतनी कहानी फ्री में तो बना रहा नहीं हूं. यूपीएससी के प्रीलिम्स में एक लाइन रहेगा, डीपीएसपीज प्रमोट laissez-faire स्टेट. ट्रू और फॉल्स? फॉल्स. सो डीपीएसपी इज अगेंस्ट द आइडिया ऑफ, प्लीज राइट, डीपीएसपी इज अगेंस्ट द आइडिया ऑफ, डीपीएसपी इज अगेंस्ट द आइडिया ऑफ laissez-faire स्टेट. यू सी, Narendra, Rajiv, Vidhi Chauhan. Okay, so that is the welfare of the poor. The welfare of the poor is taken care by the state. You please write Article 36. Article 36 of the Constitution. Just write Article 36. Article 36 provides for the definition of state for DPSP. Article 36 provides for the definition of state for DPSP. I'll come. Okay. Provides for the definition of state for DPSP and provides for the definition of state for DPSP, and it is same as that of part 3. Very good. Please write further. It is same as that of part 3. Next you write, यानी जो स्टेट का डेफिनेशन पार्ट 3 में है वही स्टेट का डेफिनेशन पार्ट 4 में है. तो जितना भी स्टेट आता है पार्ट 4 में, वॉट एवर क्वालिफाइज एज स्टेट इन पार्ट 3 हैज टू अप्लाई डीपीएसपी ऑल्सो. सो दिस इज समथिंग विच इज देयर. ओके, सो द डेफिनेशन ऑफ स्टेट इन पार्ट 3 में जो स्टेट का डेफिनेशन था फंडामेंटल राइट्स के लिए, पार्ट 4 में भी स्टेट का डेफिनेशन. जितनी भी अदर अथॉरिटीज हैं, ऑल द अदर अथॉरिटीज इन पार्ट 4
Part 3 shall also apply directive. Will LIC apply DPSP or not? Will Securities Exchange Board of India apply DPSP or not? Will what you call any other body, for that matter IRDA, they will apply DPSP or not? Yes, they will. Why there is a reservation in what you call PSUs? Because there is a provision of reservation and PSUs have been ruled number of times to qualify as state. Now you write Article 37 provides that Article 37 provides that directive principles are Article 37 provides that directive principles are what? Are non-justiciable yet fundamental for governance. Non-justiciable yet fundamental for governance. Non-justiciable yet fundamental for governance. And it shall be the duty of the state, and it shall be the duty of state to apply these principles in making laws. Apply these principles in making laws. Then you write the directive principles promote an egalitarian order. Directive principles egalitarian. Okay. Promotes an egalitarian order based on social and economic justice. Social and economic justice. Article 38 is like exceptionally beautiful article. I personally like this one. लेकिन हम जानते हैं अभी विद्रोह हो जाएगा. ठीक है, we'll discuss. Miss Bhardwaj will discuss Minerva Mills also once more. Don't worry. Today नहीं, we'll discuss. Don't worry. Case will come again. Okay. Up, we'll discuss right to political party. We will see actually there is a contradiction in the material, but predominantly Supreme Court has not ruled right to form a political party as a right under Article 19(1)(c). But there are few decisions by Central Information Commission. We'll come to that. Okay. So we'll see Article 38. Just 1 second. Nikhil Avasthi is asking, right to education is in DPSP and they are not justiciable. Then why Supreme Court says right to life under? Because Supreme Court is the final interpreter of the Constitution. Under Article 32, it can interpret the Constitution in the manner it likes, and right to life includes a dignified education. And the case name is Mohini Jan and JP Unnikrishnan. Okay, have a wonderful evening. Take care. Bye.